for 12:30 it was taken. I
Oh, we'll receive you. If you don't, just remind us as around 12.
yes, right.
When we come back from that break,
Man, yes.
just remind us, we'll take up
Fine.
this matter. And
I'll get you. I'm ready, my lord.
thank you.
I will
Yes.
take it.
Your Lordship, may be permitted to mention one matter under the heading application, Your Lordship.
Yes.
My lord, may I be permitted to mention this matter, my lord? My lord, this matter is from the list and determination of court room number 13.
What is the matter?
Yes,
Bail?
my lord, bail in connection with appeal matter.
Yes, yes.
Grateful, my lord.
My
Both
lord, may I be
entitled.
allowed to mention a matter, my lord? This is Order 41, Rule 11, my lord.
Yes.
My lord kindly keeps it on Monday, my lord. They
If
exist.
the file comes, it will be on Monday. Whenever the file comes, we give it in the list.
My Lord, appeal matter is inclusion.
What?
Appeal matter
Hearing?
inclusion. No. New motion matter, my Lord. Inclusion, my Lord.
Wait. No, the appeal has been admitted.
Stay has been granted by the district judge. Your Lord, August the last date.
Appeal has been admitted
No.
by us.
No, Lord. My
Then
Lord.
write order 41 Rule 11.
Yes, my Lord. Okay.
Write order 41 Rule 11.
Okay.
What? এটা call. Although a last chance was given to the petitioner to move the matter by order dated August 5, 2026, since today the regular bench, since today is not a regular day for the sitting of this division bench, we grant further accommodation to the petitioner. However, in the event the petitioner does not appear on the next occasion, ex parte orders will be passed in the absence of the petitioner.
My lord, I am for the petitioner.
Yes.
This is a can for maintenance.
You have filed your their application.
It is their application. Can is my application. I am for the petitioner wife in the can. Otherwise, I am for the respondent.
Oh, you are for the response.
My lord.
So your application.
It is
You
my
have,
application.
have you filed your affidavit of assets?
Lord, I have filed the affidavit of asset annexed with the can.
Annex with it. All right.
My lord, my lord.
Item number 2, my lord. In this matter, I am appearing on behalf of the appellant, Dipankar Vishwas. Mr. Kushal Pal led the matter. Lordship,
Yes.
only on his behalf, I am praying for 1 day accommodation. He is ill, would not turn up due to the fever. He intimated me.
No difficulty. Then we'll direct you to file affidavit to this, so that process.
Already filed an opposition to this affidavit.
Opposition has been filed.
They have served it to me. That I do not know whether
What is
filed in the court or not.
Today, I am not having such instruction. If it is filed, then
It is. They have served it to
They
me.
have a copy. We don't have it. So the time for filing affidavit in opposition and the affidavit of assets of the husband is extended till August 10, 2026. When the matter shall next be listed under the same heading, the time for filing reply thereto is also extended to the said date. You must be having a reply also.
deeply obliged to you.
But I have not prepared the reply because since there was no order to file the supplement, the
Affidavit.
reply by them. So I was waiting for the court's order, my lord. I have not prepared the reply.
Can you do it by Monday?
No, my lord. I have to
Should you keep it? Tell us.
my lord, after 15th, my lord.
আচ্ছা রিপ্লাইটা যেটা বললাম ওই রিপ্লাইয়ের ক্ষেত্রে রিপ্লাই is extended till August 14, 2026. The matter shall next be listed under the same heading on August August 17, 2026. আর অপোজিশনের প্যারাগ্রাফে যেখানে বললাম যে on which date ওটা বাদ চলে you file your opposition we have extended the date. You file your reply by you give a copy to them by 14th.
My lord, deeply obliged.
We take it up on 17th. Next.
Affidavit of service.
Obliged to you.
Article line affidavit of service file to be kept on.
Grateful, my lord, deeply obliged.
Thank you. Who is appearing? Yes.
My Lord, I'm aggrieved by an order dated 10th of January.
Mr. Bhattacharya, you are for the respondent.
Respondent.
Yes.
May I be allowed to hand up
Affidavit of service, my lord.
Section 5 has been allowed.
No, no, my lord. It's coming
is
for
the
the
delay?
first time.
What is the delay?
84 days.
84. Reason?
My lord, the order was passed on 10th of January. I was informed about the order on 28th of March, but I have filed it on 24th of April.
Yes, Mr. Bhattacharya, what do you say to the
Yes,
section
my
5?
lord, I vote cannot be because we got the order of injunction within 24 hours. We complied with order 39 rule 3AB. Therefore, my lord, after 1 month, my lord, possibly this cannot be the acceptance. Within 24 hours, my lord, I have to file the slip, and we did
Or
that.
did they receive? Have you got an instruction on that? You might have filed.
My lord, kindly see the page 10.
Hasten directly to comply with.
Complied with, my lord, that is there. Page 13, plaintiff files affidavit of service on 2nd of February. Along with advocate's letter, 1 postal slip, let it be kept on record. Order number 3.
2nd of February. With postal slip, not acknowledgement card.
I came to know when I went for pasting the notice for possession, then I came to know about the order passed by the learned court below.
The petitioner learned counsel for the petitioner submits that the petitioner became aware of the impugned order sometime after the passing of the same, when the petitioner's agent went to paste notice on the subject property. First of next para, thereafter, the matter took some time to be vetted by the appropriate officials, upon which the appeal has been preferred. First of next para, learned counsel for the respondent submits that the respondent, who obtained the order in the trial court, duly complied with the direction of the trial court to put in due requisites for service of summons as well as copies of the application and its annexures, temporary injunction application and its annexures on the present appellant. First up, it is also pointed out that in the order dated February 2, 2026, the learned trial court also recorded that affidavit of service along with an advocate's letter and a postal receipt was kept on record, indicating that service was effected much prior to the date as claimed in the condonation application. However, even from the order dated February 2, 2026, we do not find mention of any acknowledgement having come back with the endorsement receipts and or any clear indication that notice had already been served on the appellant on the said date. Thus, we find the grounds made out in the condonation application to be plausible and cannot attribute any malafidez to the appellant. Hence, can 1 of 2026 is allowed, thereby condoning the delay in preferring FMAT 145 of 2026. The Prothome affidavit of service file to be kept. Yes. What about the appeal now?
Yes, madam. If your lordship kindly comes to the certified copy of the impugned order.
Yes, yes.
If your lordship kindly comes to order number 2, 10th of January. I'm so sorry, my lord. I told my lord that 10th of January order, but it's of 31st of January.
Yes.
If your lordship kindly comes to my lord, may I be allowed to read it out? Then
Yes,
I can show.
Yes.
Learned advocate for the petitioner filed an application under Order 39 Rule 1 and 2 read with Section 151 of the CPC. Office report says no caveat has been filed. There is an endorsement by the petitioner that no intimation of caveat has been received.
Yes.
The learned advocate for petitioner moved the injunction petition for ad interim protection. Now, my lord, I'm going to the operative part. Learned advocate for petitioner stated that the petitioner a law-abiding citizen and working for gain at so and so. My lord, address is very important. 126A Bidhan Sharoni, Kolkata 4. Opposite party finance company sanctioned a loan of rupees 30 lakhs in favor of the petitioner, and petitioner was asked to give some security for the said loan. The petitioner happens to be the owner of the property being date number so and so. It is further stated that stated from the side of the petitioner that the opposite party asked the petitioner to keep the said deed of the suit property deposited as a security of the said loan. Under such compelling situation, due to dire financial need, the petitioner kept the title deed in respect of the aforesaid property with the opposite party as a security of the said loan. It is not disputed the transaction was commercial in nature. It was declared and assured from the end of the opposite party that on payment of the entire loan amount with interest and said title deed will be refunded and or given back to the petitioner, and no objection certificate will be issued to the petitioner in respect of the said loan. The petitioner paid a sum of rupees 20 lakhs and odd out of 30 lakhs to opposite party, both against receipt and without receipt, by check as well as by cash. In spite of making payment, the parties got embroiled in a dispute in respect of a said loan for the reason aforesaid several sittings held with the opposite party. But the opposite party asked the petitioner that unless the petitioner acts as per their dictates and to fulfill their demand, the property which given by the petitioner as security at any point of time will be sold. Accordingly, petitioner pray for temporary injunction restraining the opposite party, its main agents and associates from transferring in or encumbering the suit property being deed number so and so, or from disturbing the peaceful possession of the petitioner in respect of the said property more fully described in the schedule of the plaintiff. It is submitted that the interest of the petitioner will be jeopardized if no ad interim order is passed at this stage upon perusal of the materials on record.
Service Act. Securitization. Yes, please carry on. Yes.
It transferred that there is urgency involved in the matter. Now at the ordering portion. Having heard the learned advocate for the petitioner and also having perused the materials before the court, it appears that the stage, if no ad interim order is passed, then the petitioner will suffer irreparable loss and injury. How? Not recorded. It is found that a prima facie case has been established as this stage the prayer may be considered. How? Why? Not recorded. For an ad interim order is passed, then hardly any prejudice would be caused to the opposite party. And how the opposite party will face the irreparable loss? Not recorded. Therefore, keeping in mind the principles of balance or convenience or an inconvenience, the prayer for ad interim injunction may be allowed for a short period. Considering the urgency in the matter, the prayer for ad interim injunction is allowed at this stage.
Have you taken out a section 13.4 notice? 13.4 to
Yes, yes.
what stage? 13.2 or 4?
13.4.
I came to know about this suit when I went for pasting the 13.4 notice. And they have received 13.2 and they have suppressed.
So at the stage when the suit was filed, 13.2 was there, 13.4 had not yet been pasted.
Yes. And I'm carrying that 13.2 notice which they have received.
Let us hear Mr. Bhattacharya. Yes, Mr.
No, one.
Yes.
My lord. Accordingly, it is directed that the opposite party, its men and agents and associates are restrained from selling, transferring and assigning and or creating any third party's interest or to part with possession or disturbing and or interfering with peaceful possession of the plaintiff in respect of the suit property being deed number 4122 for the year 1979, subject to the condition that the petitioner will go on depositing 20,000 every month in the loan account of the petitioner till the liquidation of the loan. So, my lord, my agreement got altered by the learned court below. Now, my lord, if your lordship kindly takes up the plaint one. Plaint ta koto page ache bolo.
17. Page 17.
Yes, 21 is the relief.
If your
17
lordship-
start, 21. 17 starts, 21 is the relief.
21 is the prayer.
No, my lord, before that kindly comes to paragraph 6 at page 18.
Yes.
My lord, kindly, I pressed for recording that address. My kindly see is in the cost title, address is same. 126A Bidhan Sharoni, Kolkata 4.
Page 20, para 6.
Page 17, I'm sorry, in the cost title.
Yes,
Page
yes.
17.
Yes.
Same address, my lord. Now, my lord, kindly comes. Page 6. Page 18, paragraph 6.
Seen it, read it. What is your contention?
There is no branch situated, and my lord, they only mention to draw the jurisdiction of the court. They mention and court has considered. And more mournfully, this is a suit for property. My lord, property situated at district only.
district?
Hooghly. Memory Hooghly. Now the order of injunction passed by the learned citizen.
Might have been a case of memory loss. So different address. So if it was Rammohan Sarani, they have filed the suit where?
Before the learned civil court,
Rammohan Sarani is not. It's also under.
within the jurisdiction of learned 10th bench civil court.
Vidhan Sarani is also within city civil court.
City civil court, but the specific court is not having that jurisdiction. They are mentioning that branch is situated at Vidhan Sarani, but the manager called them at Amma Street.
Probably at his home. We don't know. Anyway, so let us hear him.
Yes.
Yes, Mr. Bhattacharya.
Milord, two things, Milord. One, Milord, this appeal was filed, Milord, sometimes in April. Now, Milord, we are in middle of August.
How do you support this order? This is
Party
contravention of
order of
34.
injunction, Milord, if they were so aggrieved by
No, we are on
RTC,
jurisdiction. Section 34.
34, Milord, 34 is there, Milord.
Not only present, but future.
34
To be.
Milord, when the Milord suit was filed, Milord, there was no notice. Perhaps it was
13 to.
that was perhaps after, Milord, they got, Milord, the I do not know, Milord, about
we
the
are
notice.
relying on Mr.
My notice is of 11th of November 2025.
When was it served? That is the old.
We don't know, but
Yes.
at this stage we cannot look into it.
Yes.
But 34, the second part says in respect of any no injunction in respect of any action to be taken in pursuance of it. So you admit a loan, you admit that there was a default, there were talks between you, and this is rewriting the contract also. This is not an ordinary case where if the Surface Act was not there, we can understand subject to payment of
Section 9,
some
Milord,
security.
230.
Yes,
Yes. But, Milord, this is
what
what has,
admitting and allowing the appeal.
Milord, this
Short point. This
there
is
is, Milord, there is no, Milord, application, Milord, for, Milord, rejection of plaint or, Milord,
So remedy lies, where under this act. You go there, and now 34 has also been filed, so you go there.
Milord, true. Milord, I will do
You
that.
can add one line that this will not prevent you from going there. If it
Definitely.
helps you
It has to be.
vis-a-vis your client.
Kindly, yes. Kindly, Milord, gives Milord some breathing period. I will, Milord, Milord, within 1 week, I will apply within
No,
the.
you don't have a right to breathe nowadays.
Kindly, Milord, they have, Milord, not.
They will pass a judgment
If-
saying the right to breathe is also
From
part of the
April
right
to
life.
August, Milord, if they were so aggrieved, Milord, they did not, Milord, move their appeal.
So, what
Another
the
one-
moment your client came to you, the breathing space started. You must have advised him what to do. It is already drafted. It will be filed the day we dismiss this.
1 week,
We
within
allow
1
this.
week. Milord, by Wednesday or Thursday, we will file it, Milord.
In 1 week, they cannot do anything. How they'll have to give a notice, put it up on sale. The sale notice cannot also be completed within one week.
I'm only
Position
praying
is
for
still with
this.
them. How can
Yes.
I even see?
I'm only, Milord, praying for this breathing period.
Additional portion 13.4 has been pasted. So they cannot go further. At this stage, section 14 does not come in.
This is, Milord.
We will get 1 week in any event.
And my this transaction was of a commercial transaction. That was
30 lakh, what is the
so far
limit?
city court is concerned, it is 3 lakhs.
Oh, 3 lakhs.
বাড়েনি এখন?
না
Notification
না
হয়েছে?
না না বাড়েনি শুধু বাইরের গুলো বেড়েছে কলকাতার তো বাড়েনি
Up to 10 lakhs,
No.
10 lakhs,
Yes,
from
yes.
10 lakhs to 1
Maybe-
crore
maybe
concurrent and up
I-
to
I-
Record your contention that
original side of the high court.
record your contention. This is commercial. We will keep that open to be decided in the suit, and you can take that point in the suit. We are not going on that,
Yes,
but on the other grounds we are. In view of arguable questions having been made out, the appeal is admitted to be heard on the grounds taken in the memorandum of appeal. Full stop. The conspectus of the appeal is brief, and as such, we take up the appeal for hearing along with the connected application, since both sides are represented through counsel. Full stop. Next para. The primary objection raised by the appellant to the impugned order, which was in respect of an immovable property, which is admittedly a security for a loan taken by the plaintiff stroke respondent, is that the appellant bank has already issued a notice under section 13 within bracket 4 of the Surface Act 2002. Full stop. At least prior to the filing of the suit, it is submitted, a section 13 and a notice under section 13 within bracket 2 of the said act was also issued to the borrower stroke respondent. Full stop. Next para. Thus, it is contended that the injunction granted, ad interim injunction granted by the learned trial judge is squarely barred by section 34 of the said act. Full stop. Next para. Secondly, it is contended that the learned trial judge granted injunction without recording any appropriate reasons, merely paying lip service to the yardsticks for grant of injunction. Full stop. Thirdly, learned counsel for the appellant contends that by imposing a condition for the injunction to the effect that the appellant will that the respondent will go on depositing rupees 20,000 every month, the learned trial judge virtually has rewritten the contract between the parties. Full stop. Next para. Moreover, learned counsel submits that in view of the nature of the transaction and the valuation of the suit, the dispute relates to a commercial dispute and thus ought to have been filed before a commercial court as envisaged under the Commercial Courts Act 2015. 2015. Full stop. Next para. Lastly, learned counsel for the appellant argues that from the plaint itself, it would be evident that the address of the bank is different from that where the manager of the bank allegedly met the respondent. Full stop. Thus, it is contended that the suit ought to have been filed not only before the commercial court having determination, but the appropriate court having territorial jurisdiction over the concerned police station where the where the branch of the bank is situated. Full stop. Next para. Learned counsel appearing for the respondent submits that the respondent did not receive any notice under section 13 within bracket 4 of the SURFACE Act at the relevant juncture when the injunction order was passed. Full stop. Anything else, Mr. What should you record?
Milord, this is one. Secondly, first order of injunction has been extended. Milord, subsequent extensions have not been challenged. And Milord, this appeal was filed on 28th April till August. They did not move. Therefore, extreme urgency, Milord, to challenge the nex parte ad interim order of injunction.
Next contended that the present impute order has subsequently been extended, which has not been challenged by a separate appeal. Full stop. Next para. Moreover, the element of urgency is entirely absent on the part of the appellant, in view of the delay in preferring the appeal. Full stop. Next para. Insofar as the question of delay is concerned, we since we have condoned the delay on being satisfied of the grounds for preferring the appeal late, we cannot reopen such issue, and we deem that the appellant came within reasonable time after coming to know of the impugned order. Full stop. Next para. Moreover, the mere fact that the impugned ad interim order has subsequently been extended does not make any material difference, since an extension, double inverted extension, by very definition, means the extension of an order which is already subsisting. Full stop. Thus, it is the parent ad interim order which was initially passed, which is being extended subsequently, and as such, if the parent order itself is assailed and such challenge is successful, the effect would be that all extensions thereof would automatically go. Full stop. Next para. Regarding the valuation of the suit property and the matter pertaining to a commercial dispute, we leave it open to the parties to canvass such issue in the suit before the learned trial judge, since it would be premature to delve into the issue at length at this juncture. Full stop. Next para. However, we find substance in the other contentions raised by the appellant. Full stop. It is palpable that throughout the plaint and the temporary injunction application, the plaintiff / respondent categorically admitted that the transaction emanates from a loan, for which the subject property was given as security. Full stop. Next para. Thus, since the bank has already initiated action under section 13 of the SURFACE Act, the bar under section 34 of the SURFACE Act to the jurisdiction of the civil court is squarely operative. Full stop. Insofar as the injunction is concerned, the bar extends beyond the scope of a suit or proceeding. Full stop. Whereas a suit or proceeding cannot be instituted if a notice under section 13 within bracket 4 has been issued, comma, the bar to grant of injunction by the civil court is couched in the language in section 34 that it shall not be granted by any civil court or other authority in respect of any action taken or double inverted to be taken, double inverted clause, in pursuance of any power conferred under the Surface Act. Full stop. Thus, comma, the expression double inverted to be taken also encompasses future course of action under the Surface Act, comma, if available to the bank stroke creditor. Full stop. Keeping in view such bar, comma, we are of the opinion that the learned trial judge acted dehors jurisdiction and contrary to section 34 of the Surface Act in granting injunction which potentially debars the creditor stroke appellant from taking measures under the Surface Act. Full stop. Next para, also, comma, by imposing a condition of payment of an amount of money monthly by the appellant, by the respondent, comma, which is entirely different from the original loan agreement between the parties, comma, the trial court, comma, even at the ad interim stage, comma, has virtually rewritten the contract between the parties. Full stop. Next para, thus, comma, the impugned order cannot be sustained. Full stop. Accordingly, comma, FMET 145 of 2026 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 2 dated January 31, 2026, passed by the learned judge in charge, comma, 10th bench, comma, City Civil Court at Calcutta in title number 296 of 2026. Full stop. Consequentially, comma, all subsequent orders extending the same are automatically denuded of their strength. Full stop. Next para, we make it clear that nothing in this order shall preclude the plaintiff stroke respondent from taking recourse to appropriate legal remedy as contemplated under the Surface Act, comma, if the respondent so deems fit. No rest to cause urgency. Consequentially, Can 2 of 2026 is also disposed of. No rest to cause urgency.
Marvelous. May I take your leave?
Please. Yes. Yes. Bad start to the morning. Next. 4.
Milord, I appear for the appellant, Milord. There is a application, Milord, under section 5, Milord.
It's like a turn-code debate.
Milord, I have to servant.
Section 5 what?
Section 5 stay, Milord, both two applications.
This is against injunction order.
No, Milord, final dismissal of the suit.
Why misappeal?
It should have been, Milord, classification has to be, Milord.
Let us just check up. Otherwise, you cannot pass. If you pass an order,
Yes.
that will not be recorded. Yes, so it is dismissed.
Section 5.
We find that by the present appeal, comma, the
বলছো তুমি নন রেসিডেন্ট আর কলকাতারই অ্যাড্রেস দিচ্ছ
ex parte dismissal of a suit
কি করে হচ্ছে
has been challenged. Full stop. Since the same is a decree within the contemplation of section 2 of the Code of Civil Procedure, comma, a regular appeal would lie and not a miscellaneous appeal. Full stop. Accordingly, leave is granted to the learned advocate on record for the appellant to carry out the necessary amendments to the memorandum of appeal by indicating that the appeal is from an original decree instead of an original order. Full stop. Such correction shall be carried out during the course of the day. Full stop. The matter be sent down, the office shall, comma, accordingly, comma, allot a new FAT number to the appeal. Full stop. Upon such number being allotted, comma, leave is granted to the appellant to mention the applications for inclusion in the list.
কারেকশন টেকনিক
Do that immediately mention?
Yes. এফএটি লিখে দেবে অ্যাপিল ফ্রম অরিজিনাল ডিগ্রি
I am appealing, my lord, for the appellant,
Yes.
defendant number 1 in the suit, my lord. Against an ex parte ad interim order. My lord, the plaintiff is a flat owner of a multi-storied building claiming a right in a contiguous property.
As common space or
Purportedly trying to say, not that is what I'm going to say, my lord, that declaration which he is seeking is contrary and beyond the schedule of his deed of conveyance.
Mr. Thakur, please take your seat. Yes, no difficulty.
That is the first issue, my lord, which I am
Sorry,
raising.
we missed the last part.
Yes, my lord. The
Declaration that-
declaration which is asking for in respect of the property which is described in the schedule to the plaintiff is beyond the schedule of his own conveyance, as well as the conveyance of his predecessor. So, my lord, my first case will be that he can have only a flat owner can have only a right in the common areas and amenities of that multi-storied building. That is what his conveyance grants him that right. He cannot seek a declaration in respect of a contiguous
He
property.
has claimed exclusive title. I mean title.
Yes, declaration that he has a common enjoyment of over that area.
Common enjoyment.
Yes, common enjoyment. But common enjoyment is also something which is conveyed to him by the deed of conveyance. Because what he is conveyed a title in his flat together with proportionate rights in the common area. Common area is described, my lord, in the conveyance deed. What is the common area? Now the schedule which is described in the plaint and the case which is making out in the plaint is beyond his conveyance. That is what I am going to show your lordship, my lord.
Taking a right.
Undivided share, yes. Now, my lord, if your lordship kindly takes the plaint for once, my lord.
Yes.
69 of that.
Kindly come to page 69 of the Can 1.
Yes.
Kindly see plaintiffs have described themselves as the unit number such and such 3 on the 9th floor of this project in the cause title. I am defendant number 1.
Yes.
Now your lordship will kindly see is
What are you, the developer or?
I am the owner of the contiguous property,
Oh,
which is 36A. Your lordship will note defendant number 1 is the owner developer of 36A. Plaintiff is the flat owner of 36B.
What are the other defendants? Why are
Other defendants, my lord, are the developers of another property 37, which is developed by a common developer as the plaintiff's property. So, my lord, he is saying 36B is one property which the plaintiff has the flat, 37 is the other. In between, I have a land which belongs to of which I am the owner and lessee, and he is saying that 36B, that is his property, and the other one 37 is joint. Unfortunately, my lord, there are 3 separate sanction plans in respect of 3 separate premises. Sanction plan does not show any jointness. So, well, this is the case which the plaintiff is trying to make out, that his apartment where he is having the flat, that has a jointness with another property which is 37. In between is my property. Plan map. But I have prepared one schematic diagram. Your lordship will get that in paragraph 2. Your lordship will see project Fort Oasis has been constructed by Ford Group. Defendants herein are all part of Ford Group. Not correct. Defendant number 3 to 20 are landowners of 36B. Defendant number 2 is the owner of adjoining premises 37, which was previously 37, 38, and 38 by 1. Defendant number 1, that is my client, long-term lessee of 36A. 36A is in the middle. And I will just show this by way of a schematic diagram.
36.
I'll just kindly see. This is actually the diagrammatic representation. But your lordship sees premises number 36B on the left. There is the plaintiff's flat. absolutely on the right is one of the old premises 38/1 amalgamated to 37. This 36B and 37 have been developed by a common developer, Ford Group. And I am in the middle, premises number 36A, which is completely different. This is the possession of the three buildings. Now I show your lordship, my lord,
The
plaintiff.
driveway in between the.
That is what he's trying to say. Now, my lord,
Described
therefore,
as a driveway.
he
the schedule.
is claiming a schedule
Yes.
as a driveway on my property.
Not on your property.
Yes, if your lordship sees, my top is where the driveway is being purported to be shown. That is 36A.
Achha. That is also within 36A.
That is actually, my lord, original records will show that there was a defunct corporation drain which has been leased out to my client. Now, I'm not going into that. I will just show, my lord.
Is that the ad interim, ex parte ad interim injunction?
Yes.
The written objection is already filed. The matter is listed on 28th August for final hearing. There's an order 7 rule level.
They have, my lord,
They filed
they have
written
got,
objection prior to filing this appeal.
yes, but what can I do? But whenever I go,
They have both remedies.
But
Can
once the written objection is there, hey, your lordship.
but it
yeah,
is
I'm not doing
automatically
this. If it's
extended.
a recent order,
Yeah, I'll come
very
to that.
strong reason for us to
Well, I'll just
think
show.
about sending it back, but still they have the right to prefer an appeal.
But kindly see once their deed of conveyance.
Yes. It's a sort of easementary right they have claimed.
But subject to being granted in the deed of conveyance.
But the difficulty is in Mr. Thakur's plaint. They don't say it's an easement. They say undivided share in interest. That is the
Exactly.
difficulty.
As if
Not
it,
right of passage.
yeah, as if it is a common area of their building. That is what I will show from their conveyance, my lord. My lord, if your lordship sees the schedule of the plaint before the conveyance, page
Yes.
84 is the schedule of the plaint.
Page 83
Yes.
in our copy. Yes, we've already marked that.
Driveway connecting 36B and 37.
Yes, that's how we asked you whether this is there.
Yes. So, my lord, therefore, this must be part of the two plans also. 36B plan and
We're
37.
not answering that right now. We're not answering that question right now. Yes.
But it is my submission
Yes.
that if they claim
Registered.
there is a driveway, that must be reflected in the two plans as also in their conveyance.
Registered. Registered.
But kindly come to the conveyance once.
Yes.
This the schedule to their conveyance is page 42.
stay application in respect of second appeals. FMAT
No, is your lordship is saying FMAT 236 or the other one?
Oh, the page number did not tell you that. This is FMA 813. We don't know what FMAT
This is the first appeal. This is the second
probably
appeal. Is a subsequent appeal.
তোমার কাছে page number করা আছে?
Second appeal copy.
FMA 813.
Well, if it is convenient, my
It
lord,
was FMAT 217.
but if the other appeal can be shown to your lordship, my lord, my page numbers might tally.
Another appeal. Very.
131 তো নাকি? 131 if your lordship sees from it. The schedule of the conveyance.
No, but here the schedule of the plaint first.
Yes,
Schedule of the plaint is why two appeals?
because one of the order was extended. Oh.
Schedule is at page 84.
Yes, this tallies with me, my lord.
This is against the extension.
This is against the extension.
পুরো রাস্তাই শুনবে নাকি? ছেড়ে দিয়ে এবার সিজ করা শুরু করো। Page 131.
131 is the schedule. My lord, I just show your lordship, my lord.
Yes. This is the Mr. Thakkar's client's purchase deed.
Yes, purchase deed.
Mr. Thakkar, do you spell your name, pronounce your name as Thakkar or Thakkar?
Not, this is the anglicized version. It should actually be Thakkar.
Thakkar. Thakkar is the real one.
Thakkar is the real. In Ahmedabad, they would say Thakkar.
Yes.
Now the schedule to dekhiye dakho. This one.
It's a version of Thakur, Thakre and all these things. No, it's different. Yes. Sorry, please.
Our first schedule is the entire property.
Yes.
Lordship will see that KMC drain, which I was talking about, is described as on the east. KMC drain,
Was there any map to the deed?
no. Well, kindly come to 132,
Yes.
second schedule, description of the property hereby conveyed, residential flat, such and such, 2 covered car parking space, Fort Oasis, 36B.
So
We-
B is what is actually second schedule is actually what is conveyed.
Is actually conveyed. And also kindly see what is the common area facility which is here.
Yes, seeing that also, right?
So none of the common area in third schedule talks about
Driveway.
a driveway or a motorable road, which is the part of the schedule. And my lord, the main part of the deed also, which shows what is conveyed to him,
So page number 124.
124. Now this deed witnessed, but 124, your lordship will see consideration of such and such.
All that. There is
Grant sale crown assigned unto in favor of all that residential flat super built up area on the 9th floor. Sorry.
Yes, nine. Same.
Together with in premises described in second schedule, right to use and enjoy in common other areas more fully described in third schedule.
Yes.
So this is the third schedule. This
Now,
is
apparently till now their best case could be page 132, Mr. Sen.
yes.
The last 4 lines of description of the second schedule, together with the proportionate share or interest in all the common parts, portions, etc.
Yes.
And together with undivided proportionate share in the land, forget.
Yes.
So proportionate share or interest, they have claimed undivided share.
In the land
of the complex.
of their complex.
No, in the plaint that
Yes.
they have claimed in the suit, the relief is undivided share over the driveway,
But the driveway must form part of the common
area.
That
To
is why I was
under this,
that
to
is why I was showing third schedule.
common areas and facilities. Fair.
So if the driveway is mentioned in the third schedule, then second schedule and third schedule read together, they will have an undivided share in the common area, which is the driveway together with motorable road.
Because third schedule starts with the common areas and facilities mentioned in this deed.
Shall
And
include.
common areas has been mentioned in the second schedule.
Yes. Common area is described specifically.
Yes.
In respect to 36B.
Understood.
And this is only in respect of 36B. Now, my lord, kindly, now, my lord, even their predecessors' conveyance deed is also here. There is no difference, same. Now, my lord, in this perspective, kindly see their plaint case. Can this sort of a declaration be claimed? And on the basis of this declaration, can they make out a prima facie case in respect of this? But if your lordship comes back to paragraph 4 of the plaint, page 75. Paragraph 3, they have mentioned about their title, deed of conveyance. Paragraph 4 says, all the aforesaid 3 premises are contiguous to each other. Very well. Ford Group, through defendants, has conceived the project Fort Oasis as a larger project comprising 36B and 37. I am not involved in 36B and 36.7. As part of such project, it was
36B
is there. 37 is
yours
there.
is 36A.
Mine is 36A in the middle.
Right.
As part of such project, it was agreed between the defendants. I am not a part of that two project, so I cannot be part of that agreement at all. Between the defendant and
You are only a neighbor. You only no way connected with their thing.
yes, I am a neighbor. It was agreed between the defendants herein that the kindly was this line that the central lawn with motorable road connecting premises 36B and 37 would be constructed and would remain part of common area and facility of the project Fort Oasis. For such purpose, the agreement was executed between the defendants. We have not seen, no one has seen the agreement. The court has not seen this agreement.
That agreement is not a part of their.
No. And their conveyance is subsequent to the so-called agreement. Even if I assume that the agreement existed, final rights crystallize on the basis of this conveyance. Even if the agreement exists, if they have not been conveyed this so-called motorable road, then it is a cause of action against their developer,
Who is not a party.
who is not a party. They have not implemented their developer a party in this suit. Now kindly see paragraph 5. On such representation that there was so-called agreement, and by virtue of creation of such common facilities, flats have been sold at the Fort Oasis by Fort Group to several flat buyers, which includes plaintiffs and their predecessors. I am not involved. This is the cause of action against their developer. The aforesaid agreement for sale dated 23rd September 2009 and indenture of conveyance dated 28th December 2012 also clearly record and confirm that such central loan and motorable road connecting premises number such and such are part of common area. Unfortunately, my lord, the record is here, the conveyance is here, the schedule are exactly similar. Their predecessor's conveyance does not have that. Undivided, last two line of para 6, undivided proportionate share or interest in the common area, including the suit property, has already been conveyed and transferred by Ford Group. This is contrary to their conveyance. Suit property is not described as a common area in their conveyance. This is my principal case. Now, my lord, kindly see paragraph 7. It is on the basis of the aforesaid that two main gates for ingress and egress of the project have been constructed, one each on two ends of the project, located at the entrance of 36B and 37. Again, does not concern me. They have a gate in their property, they have a gate in their developers' other property. The residents of the project used both the gates for ingress and egress, and in order to use the same in the manner, now this is important, you can use it for ingress and egress. And in order to use the same in the manner, central lawn and motorable road created at the project is essential. So you are saying that there has to be a central lawn which is to be created. It is not there with you in the conveyance. Such position has continued without any obstruction since the year 2012 when the two gates have been in operation. But here, my lord, comes the question, there is no case of any motorable road here. Then, my lord, kindly see, while the plaintiff and the other respondents of the project continue to enjoy the central lawn and the motorable road without any interruption or disturbance, plaintiffs found that a new building was constructed at 30. This is first time my case, my property. I am constructing in my own property, 36A, being the portion of the property held by defendant number 1 under long-term lease, such and such. Defendant number 1 maintained tin shed at premises 36A and other three sides of the existing. It was learned that independent is being constructed. They have no grievance with my independent building. This 9. Recently learned that defendant number 1 was proposing to encroach into the motorable road and the central lawn of the project Fort Oasis. So the suit is made in such a manner that they will try to encroach upon my property and claim a declaration there.
In the plaint, within the four corners of the plaint, it's nowhere stated that that driveway is a part of 36A.
Yes.
But you say it's a part of 36A.
No, I say, yes, it is part of 36A.
You are 36.
Yes, because that is the KMC drain, which they have shown as part of their eastern side boundary.
Because in para 10, they say that shifting the boundary line of premises number 36A by encroaching upon. So there's an allegation of you are encroaching upon the driveway which is not a part of 36A.
So, my lord,
you have to go by the plaint case at the ad interim stage.
Number 1. Number 2 is, my lord, your lordship will go by the plaint case together with their admitted documents.
Yes, definitely.
Now, my lord, even worst case, my lord, if this so-called central lawn is claimed as in here that we are trying to encroach upon, but unfortunately their title is not reflected in that part at all.
All right.
This is, my lord, is very important.
On their plaint, they were not entitled to.
They have no right in respect of that motorable road and driveway, at least from their conveyance. Now, my lord, kindly see paragraph 11. They are trying to fall back on that so-called January 2006, which precedes their conveyance title document. That by virtue of the arrangement between the defendants and the fact that the instrument dated such and such executed between the defendants and on the basis thereof conveyance deeds have been executed in favor of flat buyers at the project Fort Oasis. The motorable road and central lawn are part of common area facility project. None of the defendants have any. So this, what I will say, demolishes their case of para 10. Para 10, they are saying that I am encroaching upon that motorable road. But they have to show that motorable road is part of 36A. 36A land has been described in their conveyance. Conveyance does not show the motorable road and driveway. So it is an inconsistent case to make out a cause of action.
They keep it vague as to under which premises that driveway falls. They say only between 36B and 7.
Yes.
So apparently meaning that it cannot be either 36B or 37.
Cannot be.
Between means it's not either.
Yes.
In their conveyance, Mr. Shen, is there any reference to any agreement by date of 5th January?
Recital. In the recital. I will show you, Lordship.
Mr. Thakur, before Mr. Thakur places, you place.
No, I will definitely show that. And I will show, my lord, a recital will not override the main body of the conveyance. Because what is conveyed is in the main body.
We get your point. But what is conveyed ultimately does not contain that agreement is mentioned but not included in the schedule.
Not included in the schedule.
Body of the
170.
Kindly take, my lord, the
117.
Other conveyance.
Other conveyance.
Yes. 100 and
Relevant point.
but that relevant recital is at 117.
Privy to this. I'm not privy to their, I'm not a confirming party in their conveyance deed.
Kindly see, whereas the said premises was stroke is contiguous to premises 37, 38 and 38 by 1, which was developed by Fort Builders, and was is also contiguous to 36A, my property, which is presently under a lease of 99 years with analytical, my client. Then, whereas the said Fort Builders and AMC were also undertaking development of their respective premises and being contiguous to the premises, in pursuance an agreement dated such and such entered between the said owners developers, Fort Builder and AMC. Well, this so-called owner developer is not a party in the suit, referred to as the facility agreement, wherein it was agreed that several of facilities, we don't know whether these facilities include the driveway and the common motorable road. It only says several of the facilities hereinafter referred to the facility would remain common for all buildings to be constructed on the premises. That is 36B, there 37, 38, 38 by 1, the other Fort Group building, and 36A. So it only reflects that there will be certain common facilities. But that then that common facilities have been described in 3rd schedule. And it does not include the driveway or the motorable road, even if I assume that this agreement is there. Therefore, if it is common for all, then it is crystallized in the 3rd schedule individually. But it is not there.
এই পোর্শনটা 2009 আমি ডেটটা ইনক্লোজ করেছি deed of lease along with the sketch.
Now, my lord, if your lordship comes back to the plaint, my lord, at page 77, para 11, if I just, at cost of repetition, repeat para 11.1. Now, this is my respectful submission that this part is not evident from the agreement because it is not produced.
Yes.
Now, my lord, another thing what happened is, kindly see, they, through their association, have filed a complaint petition before the NCDRC, National Consumer Disputes Redressal Commission.
Against whom?
Against
They are
all of us.
you also.
Yes. And
They are not your consumer.
that is the point. Well, in the written objection, we have taken this point of maintainability.
There.
Yes. On the date is very important, 13th of May. Our written objection was served. 15th of May, this suit was filed by these two flat owners
Who are members of that association.
who are members of that association, who are the complainant before the NCDRC.
Yes.
So, my lord, the date is very important. paragraph 13, last line, they have said plaintiffs by of disclosure state that the association through its office bearer had approached National Consumer at New Delhi for several grievances. Notice has been issued. They are saying that the plaintiffs are seeking enforcement of personal rights, so there is no commonality in the two proceedings. Now this suit was, that is the date, but now your lordship will kindly see paragraph 12, if your lordship sees. 12 for the 14th.
Urgency order 2024 এর কেস আছে দেখুন the latest exchange.
Then, my lord, they say in paragraph 12, my lord, there was exchange of letters. They claimed this. We replied to that. Now, to make out this cause of action, paragraph 14, they say January 2026 meetings were held. And May, kindly see paragraph 15. This is the ultimate cause of action. On or about May 7, it was found area around a new construction being undertaken at the adjoint was cleaned up, and it has become a particular process of shifting its encroachment and merging the suit property and adjoining premises owned by the defense. This is their so-called cause of action. But I am already in construction in a different property that they have already admitted. Now, in this perspective, may I come back to the impugned order? What is the reason given for the order? The order, first order is, my lord, of 16th of May. Order number 2.
Page 230. Page 230.
Yes.
Release date টা দেখিয়ে
No, but they claim in their schedule, page 84,
Yes.
that this is a part of this common driveway is a part of 36B and 37, whatever that
Yes.
means. Both situated at premises, all that driveway connecting such and such,
where it is
situated at premises number 36B and 37 only there.
But they don't, they absolutely vague.
Yes.
But they don't say it is within my.
No, apparently that may qualify the project Fort Oasis also. The project Fort Oasis situated at.
not project photo assess.
Mine is not project.
No, no.
But it's very difficult to read this one. Driveway connecting premises number 36B and 37, along with central lawn within project Fort Oasis.
Situated at.
Yes.
Fort Oasis is project Fort Oasis is situated at those two.
Yes.
May qualify the driveway or the fort, whatever the project.
So that is why, my lord, I started from the schedule and their deed of conveyance. my
That's
lord.
all.
But I have the 3 plans. Though, my lord, strictly speaking, your lordship does not look at any document other
Plans,
for these 3 buildings.
Distinct plans.
Distinct, separate.
we won't look into that right now, yes.
Because
We go by the plain case.
I am only saying, my lord, this case is corroborated from their conveyance. This connection is not evident from their conveyance. So, my lord, now let me just go back to the order once, my lord.
So page number 231.
Plaintiffs claimed plaintiff the owner of the residential flat at premises 37 as also 36A. Firstly, my lord, this is wrong. They are not claiming as flat of 37, only 36A. Then, my lord, kindly see towards the middle. Defendant for the Ford Group had conceived as a larger project comprising of 36B and 37. Contrary to the plan, it was agreed between defendants. Central plan with motorable road connecting premises of 36B and 37 would be constructed, would remain part of the common facilities and amenities of Project 4. For such purpose, an agreement dated 5th January was executed between the defendants. On such representation, by virtue of creation of flats have been sold by Ford Group to several flats, which includes plaintiff. Recently heard that plaintiff was proposing to encroach into the motorable road. Now, this case of encroachment will arise if I have a right. If I do not own this property, whether individually or as a common area, there is no case of encroachment. Now, my lord, I am not going to place the entirety. My lord, now, if your lordship comes back to the second page of the order,
This document is
in order to
Yes.
prove, this is very important, in order to prove the contention of the plaintiffs, they have produced deed of conveyance, 24 December, a copy of agreement for sale, copy of deed of conveyance, copy of letter, photographic record, evidencing long-standing use. So this is the case. 5th January is not
So their deed, their agreement for sale, their predecessors.
their
that is
predecessor.
not been looked into by
And
reasons
kindly
given.
see, there is no comment in the order that on those deeds and documents,
There's a comparison between the.
a right has been established.
Yes, no
in-
comparison between the suit property and the deeds.
Yes. Considering the entire facts and weighing, we made a good primary to go for trial. So, my lord, this is the part which I am challenging. My lord, there is no reason recorded as regards their title.
So KMC partner, this was not in existence when the transaction happened.
Yes.
2006. NHP দিয়েছে KMC তো আমাকে 2009 সালে দিয়েছে।
And I have, my lord, this I have annexed the deed of lease by KMC. This top portion, which is the drain, was conveyed to me by lease was granted in 2009.
That we can look into only later on.
Yes, yes. But I proceed on simply on this basis, my lord.
Good.
There is no right established by their conveyance deed. Court does not record that, and therefore the case of encroachment cannot arise.
Relevant material.
All right.
My lord, these are my submissions.
Lord, may I tell Mr.
Yes, yes,
Thakkar
yes,
comes,
absolutely.
Lord?
Absolutely.
Lord, Lord, the deeds which are relied upon by the learned judge, Lord, kindly allows me to place those portions which have been relied upon by the learned judge, and I'll also, Lord, we have documents to show.
And judge has not relied on anything.
Lord, the deeds which are in my favor, Lord, I'll show. Lord, in
Portions, no portion has been relied on by the child.
Lord, portions.
Deeds, considering entire facts and weighing the balance.
Yes, my lord, that, and my lord, I will also try to demonstrate before your lordship that, my lord, my learned friend's client are part of the same Ford group, my lord, in respect of which, my lord, the KMC, my lord, has granted the lease on the representation that 36A, 36B, and 37 will all have the common facilities, including the central lawn and the motorable way. My lord, I'll show that.
Provided it's a part of your.
My lord, I will not show the KMC deed. My lord, I'll only show my
Whatever
deed.
is there.
My lord, it's recorded. It's recorded in the deeds which are, my lord.
Yes, show that.
My lord,
Yes.
my lord will kindly have a look. First, my lord, the deed at, my lord, 23rd September 2009. My lord, my lord, only one thing, my lord, we have, my lord, placing on record, my lord, 813. My lord, that is against challenge against the parent order. Possibly your lordships are seeing 236.
My lord has to
No,
just.
no, we cannot do that.
তুমি বলো page number,
My
আমি
lord,
বলে দিচ্ছি।
my lord, I'll tell you.
And since he has forced us to look into the
My
other,
lord,
he will
my
take
lord,
a different page.
my lord, I'll tell
I'll
you.
give the page number.
My lord, kindly looks at 20.
You need not do it, you'll learn junior.
My lord, I will look it. My
Competent
lord, I will
enough.
look it. I'm grateful.
They'll do
My
it.
lord, 23rd September 2009 is the deed which has been executed, my lord, by my lord, the developer is a party. My predecessor in interest is a party. My lord, kindly has a look at
Page
page
159.
158. My lord,
159.
115. I'm so grateful. My lord, 158.
Thank you.
My lord,
Yes.
I'm sorry. My lord, 159 for your lordships.
Yes, yes.
My lord, 23rd September, my lord, your lordship will see, my lord, the owners. My lord, there's a group of companies who are the owners. My lord, along with, I'm sorry.
Yes, what is their name?
My lord, your lordship will find, my lord, Balaji, Greha Nirman.
They are analytical.
My lord, no. My lord, I am referring to, my lord, page 159 of 8.
Yes.
My lord, lordship will find.
Balaji, yes.
Balaji is the, my lord, that they are the owners of the property.
Yes.
My lord, this is, I am showing how I derive interest.
Yes, yes.
My lord, Fort Project is the developer.
Yes.
And Subhash Baheti is my predecessor in interest. My lord, now lordship will directly come to page, my lord, 162, my lord, recital, my lord, internal page 3. My lord, I'll refer to the internal page number.
Page 163. your
No,
lordship.
now we can catch it.
My lord, 163, my lord.
Yes.
My lord, I'll have a look. My lord, kindly has a look at, my lord, recital J to L.
Yes.
My lord, this is important, my lord.
Hmm.
Kindly has it. The owners herein thus absolutely seized and possessed and or otherwise well and sufficiently entitled to 36B, first schedule, my lord, recital K.
Yes.
The said premises is contiguous to municipal premises 38 by 1 so and so, which is being developed by Ford Builders, which is presently under a lease for 99 years with my learned senior friends, client, my lord, Analytical Management Consultants Private Limited. Now, my lord, the Ford Builders and AMC are also undertaking development of their respective premises and being contiguous to the said premises in pursuance of an agreement of 5th January 2006 entered into between the owners, developers, Ford Builders and AMC. wherein it has been agreed that several of the facilities will remain common for the building to be constructed on the said properties. My lord, kindly marks this, my lord, 36B, 36, 38 by 1, and my learned senior friends, my lord, property, that is 36A.
That agreement is conspicuously missing.
My lord, that agreement, my lord,
There's the only
my
agreement.
lord, we have not seen that agreement, but my lord, I am only trying to show on what basis, my lord, this order. My lord, I'll read further. My lord, kindly has a look. My lord, those two, my lord, central lawn, my lord, and the motorable way, it is also forming part of the third schedule. I'll show your lordship. I'll bring, my lord, I'll come to that. My lord, kindly has a look, my lord, thereafter. The said, my lord, only this much, my lord, up to, my lord, I have placed up to clause L. My lord, now, right after that, there's a deed of conveyance which is executed in favor of my predecessor in interest. Lordship will come to kindly have a look at, my lord, page 100 and, my lord, 205, my lord, possibly 205, my lord, my lord, it is dated 28th September 2012.
191 এ আছে। Starts at 191.
My lord, 205, my lord, 204 is the schedule. My lord, kindly has a look at the schedule once. My lord, the third schedule. My lord, it will be internal page 14 of this agreement of, my lord, 28th September 2012. Lordship has it, my lord?
Yes.
Third schedule.
Yes.
My lord, kindly has a look. Common areas and facilities mentioned in this deed shall include, my lord, I'm skipping ABC and
Which
AB.
deed is this? Your deed?
My lord, this is my predecessor in interest
This is
deed.
Very good. Yes.
My lord, kindly has a look at, my lord, I'm skipping ABC. Kindly has a look at right after E, my lord, F, children playing area, lordship has, my lord. My lord, and K, my lord, playground. My lord, in
Motorable road.
lordship will has
Playground, yes.
playground. My lord, these are the facilities. Your lordship will find this in the third schedule of my conveyance as well.
Yes.
My lord, that, my lord, may I show your lordship? My lord, it's already been
Take it-
placed. My
take it
lord, it's
from me,
part of
yes.
the third schedule.
Yes.
My lord, may I have
Yes, yes.
This, I understand your, if I have understood correctly, kindly permit me, your lordship's query is that where do I get the right to use this property and why is it part of my schedule? Your lordships, kindly bear in mind, kindly have the document, the additional document which they rely on here, the KMC deed, by which they claim title. That's the additional document that they bring on here to say that to defeat my claim that this is their absolute
You cannot
property.
look into their document. This
Very
is
well.
not-
Then if your lordships do not consider their document, then kindly have only the plaint then and the annexures to the
Look into only the plaint injunction and whatever documents.
and
you
whatever
file.
is there. Kindly have the
Whether the
plaint.
trial court could have passed this order.
Could
on
have
that.
passed this order. Grateful. ये तुम्हारा briefing है?
Yes.
Kindly have my petition then only. Starts at page 74 is the plaint. Lordships in 69, plaint starts. Lordships inquired, why are there so many parties? 1 and 2 are the co-owners of this flat. And if lordships have page 70,
Going back to the other appeal or?
69 does the page match because I have.
Oh, no, it's matched. Yes.
It is matching?
This one is.
Yes. Kindly have, because your lordship's query was why I'm just. 1 is the appellant before your lordship. Analysis.
Yes, yes.
2 is Fort Builders.
Hmm.
And 2 onwards, all these companies which are there,
Up to 20 probably.
2 to 20,
3 to 20 was.
yes. These are all land-owning companies which together acquire 3 contiguous plots of land. There are 3 separate premises
Including there.
including there. And all these 3 premises.
That is not your case made out in the plain.
That is kindly come
You
to.
say that?
Yes. Kindly see paragraph 4.
Yes.
That is exactly the case. Kindly have paragraph 4 once, please. No, I'm sorry. It was not.
Paragraph 4, where do you mention 36A?
The plaintiffs state that all the 3 aforesaid 3 premises, 3 premises are referred to here.
He does not include this. 3 premises referred to in
Yes.
para 2.
2. Kindly, Project Oasis has been constructed by Ford Group. The defendants herein are all part of Ford Group. Today, this has to be presumed to be true and correct. This proceeds on a demurrer. My learned friend,
36A we don't find mentioned throughout the plaint anywhere. Anywhere. Apart from maybe
It is.
was a contiguous property and all.
Kindly have the last sentence of 2.
Of
Paragraph 2.
4?
Paragraph 2, please.
2, yes. Acha.
Defendant number 1.
But this is an isolated, I mean, standalone statement.
Your Lordships, kindly read this with one paragraph, sentence 1 and 2 of paragraph 2. Project Fort Oasis has been
Yes, right.
constructed by Fort Group. The
As
defendants herein are all part of Fort Group. Now, this, my learned friend prefaced his submissions by saying, I have nothing to do with Fort.
Yes.
I have nothing to do with Fort. Today, we proceed on the basis and an ad interim. If your Lordships is not going to consider any other document, then this is the statement on oath which I make. They are all part in the Fort Group. These three now these three
Paragraph 1, you also say together with Kara and including rights at premises number, including 36A.
Yes.
And also at 36A. That
Yes.
also you say. So you also have rights over 36A, you state.
Yes. Kindly have the map which my learned friend, this schematic representation which was handed over.
Yes.
And it will be clear from that. The one which Mr. Sen handed. Kindly have the map. This outer lines which your Lordship sees, they are all part of one composite complex. Three individual plots of land for several regulatory purposes acquired in different names, combined to form one large complex. The last land which is now being developed, 36A. Why he has come to court today after 12 years? Because now he's developing 36A, having utilized this. He now wants to bring this land into his area where it has been kept as part of common area. Because this forms the arterial road which connects the building 8 with building B. Now he wants to shift his boundary wall and bring it into the arterial road. That is the long and short of the matter. So unless, now kindly see the map, the photographs which I have annexed, which would show that this is a road. And this is not part of his property. Now he's trying to shift the boundary wall. Kindly have page 221, please. If I make hand over color copies. These are the color copies of the photographs and the map. Google at 220 to 2. I'm sorry, one more set. Now, after 12 years, more than 12 years, he wakes up when he's doing his construction and he wants to say that now this is part of my area and you cannot, where is my map which I can mark? Your Lordship kindly has, where it is written kinetics with Akash, that is the south.
That is the north.
I'm sorry, that is the north. I'm grateful.
Yes.
South is where it's written Fort Oasis. Now kindly see the Panditya Road is there.
Yes.
Towards the east. Now in the middle, kindly see that L-shaped building on the top. That is 37. L-shaped building on the top right-hand corner.
Yes.
Your Lordship sees where it's written Tridhara commercial something is there.
Yes.
That is premises number 37. These two premises. This is 37. And the outer boundary wall is the entire Fort Oasis. Connecting.
You put a red mark in Fort Oasis.
Yes, that boundary, which is the same boundary which more or less matches with this schematic representation. So these three plots of land together form one project. Now kindly superimpose them, your Lordship will see it's the same. I've just shown this because this was part of and this is where it shows.
The blue one is that road, arterial.
The blue one is the arterial road, which he now wants to shift his boundary 36A. He is now bringing in the arterial road here.
The blue and this color indicates it was a ditch more than a road.
Beg your pardon.
Must have been a ditch.
No, this is the main arterial road because this is the only road your Lordships will find which reads from the Fort Oasis clubhouse to the other two buildings.
Yes.
And now kindly see the central lawn which is there in my deed. That is the
36A is this kinetic. This
36A is the on the right adjacent to the blue. On the right adjacent to the blue patch. Where Panditya Road is mentioned.
Look, cannot be as per their scheme. See their scheme, please. It has to be the one.
No, this is
picture.
No, your Lordship.
Just for this, you just reverse your photograph and it will match their scheme. If you just reverse it, the shape, they just go by the shape and it matches.
It's the same. Your lordships will find where they say 36A. Kindly see the abutting on the right of
Mr. Thakur was just telling. This is that projection. Here is that 37.
36A.
37 at the bottom. Sorry, 36.
36B at the bottom. 37 is the top L.
No, 36A is at the bottom. So in this
Your lordships,
photograph, it must be
36A
this.
is here. This is 36A
This is
and this is
36A.
36A. I'm sorry. This
No,
is the
you
blue.
just reverse the photograph to match the shape. Just reverse your photograph. Color.
Reverse my photograph. Yes.
So you see the shape will match that projection.
They only have this one projection jutting out here, which doesn't figure. This
Is
is
the projection like this laterally?
laterally. Yes.
You're as good as me in this.
I'm very.
No,
I'm handicapped in these matters.
lose my way in when I drive. I mean, actually.
I see.
So
I don't
I'm a
drive.
very bad driver.
I
but
don't drive.
For a change, Mr. Shane has trained me sufficiently to.
Your lordship, I was
This
humbly
way.
submitting. Kindly superimpose it like this. This matches. Kindly keep them two together side by side,
Very good.
like this.
Yes, we have found out 36A.
Yes. Your lordship, find 36A here, and this is the Panditya road.
Hmm.
Now this is 36A here. This is the Panditya road. The blue is here. This is the bone of contention and the central lawn abutting it.
As per your photograph, it's vertical. The road is vertical.
Yes.
In this map, if you have to make it vertical, it has to be lateral. The scheme has to be taken laterally. Otherwise, you don't have the road vertical.
No, but,
Vertical.
I have not.
You show your junior, he will tell you.
Your lordship, there I don't find where they identify 36A here, because if they take this to be their premises,
36A is written at the bottom.
this is the 36A.
If you take that projection to the left, then the projection will be like this here, like this. Then also this will be 36.
Yes, I understand.
Towards kinetic.
Yes.
The building towards
Yes,
kinetic.
I follow now. Now I follow. Your lordship wants me to keep it like this.
Whichever way you keep, the one between that red fort oasis and kinetics, that building should be 36A.
No.
Yes,
That is 36B. That is 36B, the building which is exit.
No, cannot.
Yes. Yes, your lordship.
You help him. First match the shapes. The projections. You can't do it in half a minute, then I will call you and you come here and we'll convince you and then you go back.
কোনটা বলছো তুমি সাক্ষরদা? Let me just understand with the author, from the author. That's the best. From the horse's mouth. 36A. এইটা কোনটা? তাহলে এইখানে কোথায়? এটা তো Google.
Shane is equally at a
এটা
loss.
দেখো, আমাকে বলছে এটা 36।
এটা হচ্ছে 37
This is part of this
এটা হচ্ছে
37.
36,
আমারটা হচ্ছে এইটুকুনি।
Correct.
আমারটা এইটুকুনি।
Correct. We are in agreement.
But this I'll hand over a
Yes. Which has the boundaries
with some
identified.
colors.
আমার একটা কপি দিন। এইটা ঠিক। Yes.
Mirror image actually. The mirror image.
Now the dispute is on the west, how far does the boundary extend? And the brown portion which is there, the brown or the red, I'm colorblind. Kindly
এই
come.
লম্বটা
এটা কি brown or red?
Red.
এটা red.
লম্বটা তো নিচে রয়েছে।
এটা 36
এই লম্বটা নিচে রয়েছে 36। তো লম্বটা নিচে কোথায় হচ্ছে? এই লম্বটা এইটা।
এই যে এই পুরোটা আমার, এই যে গ্রিনটা পুরোটা আমার। আর এই ব্লুটা হচ্ছে 37. But this green is entirely our boundary. This green is our boundary.
আচ্ছা, so Mr. Thakur, please continue. Yes, we want.
Yes.
And paragraph 4 is their case of the
I'll
description.
come back to paragraph
Yes,
4.
yes.
I just take 2 minutes of that.
Yes.
Your lordship has seen that colored
Yes.
Color-
Color. Was following.
colored representation which is now being given.
আচ্ছা।
And if your lordship now sees the Google the satellite image which is there, the boundary which they are now showing in green, as per their premises, covers the entire clubhouse, existing clubhouse, the lawns, everything. Where Fort Clubhouse, kindly see, adjacent to the blue.
Yes.
Now these are structures which are already there. They don't claim, now they are not claiming that they want to come into the clubhouse because the structure is already there. But the vacant area which is there, the central lawn and the driveway which connects and is used for the benefit of the residents of all these three existing buildings. That is now being sought to be encroached upon because they are now starting construction in their area. So what is left as common space and utilized for the availing the FAR of these three projects is now sought to be encroached.
These photographs were a part of the track
Yes,
protocols.
all 220. That is what 222. And your lordships kindly see the photographs now. The blue tarpaulin sheet, the blue boundary which is there.
Yes.
This is all part of the common lawn which is there in the children's play area. And now kindly see the construction which is going on. This one. And kindly see the road adjacent to it. Now they want that the building doesn't, the building has a short boundary.
The tin shed boundaries that.
No, this is the lawn, which is separated from the road, contiguous, but the lawn is, the road is this one. This is the road which your lordship sees in blue in my representation. This is the construction which is going on. Now the existing boundary wall is already there. The appellants are the owners of this building which is under construction. The existing boundary wall is there. This short boundary wall, if I may refer it like that. They want to demolish this boundary wall and come onto the road and then encroach on the park. And this status has prevailed for more than 12 years. We've been enjoying this property like this. Now the status is sought to be altered by coming into this road. Today, your lordships, at interim stage, I'm on a prima facie case, not prima facie title.
Yes.
Today, I'm prima facie case, not prima facie title. They rely upon a lease deed here, executed by corporation in their favor. But that land has been subsumed within the project area for the benefit of the residents. And if this status is to be altered, then this will be irreversible today. This is the status as on date. The ad interim order which has been granted is to maintain status, physical, nature, possession as on date. Your lordship will modify and make it even more explicit. There's no difficulty that the status which is as on date is required to be mentioned till it is decided whether I have proprietary rights over this or I have easementary rights. Because I've said in paragraph 7 also that this is used for the ingress egress. Can you see paragraph 7? I'm sorry, paragraph 6. Paragraph 4, I'm so sorry, paragraph 4 onwards. The plaintiffs state that all the aforesaid three premises are contiguous to each other. The Fort Group, through the defendants, had conceived the project Fort Oasis as a larger project comprising of premises number 36B, 37. As part of such project, it is agreed that the defendants herein that central lawn with motorable road connecting premises 36B and 37 would be constructed and would remain part of the common area facilities and amenities.
Would be constructed.
Would be, and it is now
cannot be a present easement of necessity.
No, it is now constructed. It is there.
At that
point of time, when the project was conceived. For such purposes, an agreement dated 5th January 2006 was executed between the defendants.
But what you have claimed, Mr. Thakkar, is that undivided right. You are not claiming any easement right, easement of necessity, right of ingress and egress, or user of the passage. You have claimed your prayer is having an undivided share or interest in the suit property.
I have claimed a larger relief.
From your deeds, any undivided share in that part. Playground, we don't know. How can you identify which is the playground or what is the intended thing? You don't even.
The central lawn, because now this boundary, which I'm grateful they brought this out, they extend the boundary to here, which takes over the playground also. The playground is there for your lordships to see. The playground exists on ground today. Now his boundary, he says, is still here, which eats into the playground.
Let us forget their boundary for the time.
Yes.
We are on your case only.
Yes. So,
because we are totally on your case. Your deed does not show any right over this passage between 36B and 37. We don't find any mention there. You refer to common facilities.
Yes.
Common facilities you specify. You define in third schedule.
Kindly have A, please. Kindly have 132.
Yes. 132.
Kindly have serial A.
A, yes.
The beams, supports, main walls, corridors, lobbies, kindly ignore all that. Driveways.
Yes.
Driveways, entrance to and exit from the buildings. These are buildings, not building. I am buying a flat in one building.
Yes.
on the basis of driveways which are connecting the buildings, because the two exit and entrance gates are two ends of this project.
But all these are confined to 36B by dint of the second schedule.
All these are
Confined to 36B, whatever rights you have.
no building, more or less building known as Fort Oasis at premises number 36B. That is because I have Fort Oasis comprises of both these buildings.
Together with proportionate share
Share interest in all common parts, proportions in the land. So this is share in the land, which is
no, before that, proportionate share or interest in all common parts. Portions, areas, facilities, land comes thereafter. And together with undivided proportionate share in the land comprised in the said premises.
Yes. So your lordship,
attributable there. So
yes, so
said premises refers to 36B only.
yes, because I cannot claim land of 36, the other building, because their land is divided between the flat owners of that.
Now what you are claiming in the plaint, Mr. Thakur, is undivided share over a property which is admittedly not 36B. You say it's between 36B and 37.
Yes.
Whatever may be the plot number. So it's beyond 36B.
No.
But your deed gives you right only on 36B, flat whatever, and common facilities, all common parts, portion facilities, and together with undivided there too. It ends with attributable there too. Sorry, before that. In the said premises, the last line of second schedule.
That is why, I bow down to your lordships.
So we have to confine ourselves to 36B. That is
36B, but then when your lordships come to A, third, which is the common amenities, which is common to residents of A, B, both. That is entrance.
What you mean, Mr. Thakur, is if we are reading the second schedule for you once, the last portion, together with proportionate share or interest in all common parts, portions, areas, and facilities, and together with in the said premises. So common parts and facilities.
Yes.
And in third schedule, you say the common areas and facilities mentioned in this deed shall include. And therefore, you are tying up the common areas and facilities with second schedule, which confines itself to 36B only. You don't find any middle path literally. I mean,
yes, I follow. This is how the deed
will come back in 5 minutes and you just explain that to us.
Yes, yes. Clear है तो deed में रुक जाओ तो body recital पढ़ना पड़ेगा.
I'm only here, my lord.
You will stay back.
No, stay back, my lord. I will go to hospital, my lord.
So ask somebody to ask for adjournment when you take up that matter. You will grant adjournment.
No one, my only Passover, my lord. Or
Which
not,
one? Which one?
13 or not today, my lord. That not today.
Not like this. When we call it, tomorrow 13. We'll make adjourn it for the day. At the time of call, we'll adjourn for the day.
My lord.
Thank you.
13. My lord, grateful, my lord.
Thank you. Yes. Yes, Mr. Raj.
Kindly have my deed 117, please.
Yes, 117.
Whereas the said premises, the second paragraph, and
Yes, yes.
whereas the said premises, that is my premises,
Yes.
is contiguous to municipal premises number 37, 38 and 38 by 1 Panditya Road, which was being developed by Messrs. Ford Builders, hereinafter referred to, and is also contiguous to municipal premises number 36A, which is the appellants, which is presently under a lease of deed with Analytical Management Consultants, which is the plaintiff, appellant. You see the next paragraph. Whereas the said Ford Builders and AMC were also undertaking development of their respective premises and being contiguous to the said premises in pursuance an agreement dated 5th January 2006 entered into between the said owners developers, Ford Builders and AMC, wherein it was agreed that several of the facilities herein referred to as the facilities would remain common for all the buildings to be constructed on the said properties 36B, 37, 38, 38 by 1 and 36A Panditya Road belonging to the said owners, Ford Builders and AMCs.
So Tucker, what you have claimed is, if you could have understood, if it was an easement right you were claiming, common facility or amenity or right of ingress and egress. There's a quantitative difference between an undivided share, which is title,
Yes.
and a right of user.
Right.
We could have understood if your plaint prayer was that yes, I have an easement right or common facility, right of user basically.
Yes.
You claim undivided share in that property on the basis of which injunction status is granted regarding that property as a whole, no transfers. Suppose if it was a right of user, the owner of the dominant heritage would be entitled to transfer the property subject to your easement right, and it's a servant heritage there. Common facility pertains to right of user or right of user basically.
Yes.
But you are claiming undivided share. We don't find anything, and this 5th January agreement is also conspicuous by its absence.
That is inter se the owners of the premises, and it's very convenient, and of whom the appellant is one of the
But
parties.
you also, yes, you also purchased from one of them. You got your
Yes.
rights from one of them.
I got because
So your vendor or your predecessor in interest could have given you that copy.
yes,
You don't
but
produce that document.
that is why it's incorporated in the
That is the only one which gives you right actually to this.
which
That is
connects, which is the bridge, so to say.
right, absolutely.
Yes.
You put it better.
No, my
That is the only document which connects.
No,
which-
I am not
which acts
privy.
as a
My deed refers to this. That is why it's referred to in my
all
plan.
reference, Mr. Thakkar, particularly in the light of you having produced so many documents, which are convincing documents, title, photographs from Google Map. Yes, you produce so many documents. One is conspicuous. Just by claiming something, that does not plaintiff is to be taken as sacrosanct, but that does not mean, I mean, you have to establish prima facie at least.
Well, it's the order. I understand what is troubling your lordship. I hope I understand.
No, you're, I mean, you must be understanding, because this, see your plaint the prayer. If it was right of user, we probably would not have heard you so long, or Mr. Shen.
May I just read the operative portion of the order which is under appeal?
First, please come to page 82 once, and then we'll go there.
Please.
Immediately.
Please. Prayer B, if your lordship kindly see.
The decree for declaration, each one of them do not have any, they don't have any right, and
save and except being used.
They have a right of common area.
They have a right of common area.
Is what you say.
Yeah.
And A is the principal relief, is a decree for declaration.
There are two declaratory reliefs. A and B are independent of each other.
Very well. A, B is basically that they have only common
right of common user.
So it's on them, not you.
No, I am.
You, it's a negative declaration. They don't have any other title than common area, whatever. So they don't have title over that property except as
that is what I say. That is the injunction.
No, you are saying you have a right of user of that. Your deed says you have right of common facilities
Yes.
and amenities.
Yes.
Your prayer A is a decree for declaration that the plaintiffs
My
are
lord,
having
this,
an undivided share or interest in
my
the
lord, this will come to light only when the December 5 agreement is brought on record, disclosed by them or
No,
produced.
even if December 5 agreement is disclosed, that is where we are, the shoe is pinching, maybe pinching it. December 5 agreements gives you common facilities over that area, not title.
No, but if that reflection is there in my schedule 2, if I can read that into schedule 2 and schedule 3, not schedule 3 because schedule 3 is common, but
5th January says only you have a motorable road and central lawn, part of common areas and facilities.
yes,
The common areas and facilities of neither your deed nor your predecessors did disclose it clearly. You rely in paragraph 11 of your plaint on the 5th January document, page 77. Para 11, as you said, the connecting point, the
Yes.
connecting line.
yes,
It's by the instrument dated 5th January 2006, executed between whoever in favor of flat buyers. The
Connecting.
motorable road and central lawn are part of common areas.
yes.
So those were not part of common areas specifically under your deed.
No.
5th January agreement makes it so.
No, with the greatest. Under the 5th January agreement, the owners of the 3 premises or the owners of all the premises agree between themselves.
Let us proceed with on the premise for the timing that there was certain, but still that does not also give you, as per your plaint, a title to the property, undivided share.
No, my lord, if it can be, if I can argue my case like this, I am not seeking a declaration in terms of prayer. Today, all that I am seeking is they should not be allowed to encroach upon.
But your suit is the principal relief is not maintainable then. Your player B, the declaration,
Yes.
that is a negative declaration against them that loses its meaning. Suppose you isolate A. If A is not there, you cannot seek only a negative declaration against them without any structure. It will be unstructured. I seek a declaration that X does not have a title except that would lose meaning. It acquires meaning only in conjunction with A. Otherwise, only negative declaration probably.
Then, madam, may I then Lordship put the greatest of respect, madam, deciding on the maintainability of the suit itself, apropos the final reliefs, if A,
in the light of prima facie,
if Lordship kindly
whether the dots connect. I mean, your cause of action connects to this.
I follow. Now, my lord, there is an agreement of December 5, 2006 between the owners of the larger premises by which they agree that our
Motorable road and
all these are the common facilities for the entire project.
yes.
Occupants
As per paragraph 11, yes.
yes, as per paragraph. That document is not before we did not have it. That's why we didn't produce it. Otherwise, it would have whatever. Now, basis that document, I enter into a conveyance. And because my conveyance records this 5th December agreement also. That is the paragraph in the conveyance which I showed your lordship.
Because the conveyance does not in its common facilities include the motorable road. As Mr. Shane argued,
it says
if it was prior, it refers to that agreement.
Yes.
But it does not include that within your schedule.
I was thinking, my lord, that
body of the recitals, you refer to the schedule. And in the schedule, you don't include that, despite referring to the 5th January agreement. So therefore, this culminated this agreement, whatever it was there, culminated in your title deed.
His 3rd schedule, if I may just place 3rd schedule again, driveways, entrance to and exits from the other buildings. Otherwise, I would not have owner of one standalone building. It's not conceivable that he would have entrance to and exit from another standalone building.
But then the other party had to be a party to this agreement.
Driveways, entrance to and exits from the buildings. From the buildings. This is just one building which we are talking of here, which your lordship will find in 43.
All buildings are situated on 36B as per the 2nd schedule.
No, only one building is situated. Only one building. Kindly see his own map.
No, the 4 buildings are there in 36B.
Even if you come to schedule A, 1st schedule,
yes,
which is the larger area,
yes,
there 36B, it's confined to 36B only.
Yes.
It does not extend beyond that to 36A.
Grateful, Malad. That is why
so
in the
whatever
3rd
your
schedule,
rights are regarding 36B.
And the common areas as for 30 at the 2nd schedule, which includes driveways, entrance to and exits from the building.
2nd schedule says common parts, portions, areas and facilities together with undivided proportionate share in the land comprised in the said premises, referring to 36B.
Yes. So, Malad, that is
within 36B you may have
whatever is carved out. And then 3rd schedule refers to driveways, entrance to and exits from the buildings. That is not limited to the premises 36B.
Then they had to be a confirming party, the 36A owners.
I follow, my lord. Now the 36A owners would be stopped from relying to the contrary by reason of their agreement of 2006 with the owners of all the buildings, because that is the recital in this agreement. That is how they, and I am saying that they are part of the fourth group. They are part of the fourth group. It's not that they are not part. For all these years, now kindly contemplate a situation. All these years, this deed is of. Kindly give me a minute. I'll just give your lordship the date.
Yes.
Deed is of 2020. The prior deed of my predecessor in interest was prior to this. Who was the first owner? 2012. Completion certificate was given in 2011. The road is there since 2011. Today, the status is sought to be altered. Today, my lord, prayer A is claiming a larger right. Declaration that I am the owner. I can step down from the larger right and establish that I have an easementary right.
You don't claim any easementary right to a plane. You say that they don't have anything apart from easementary right.
Paragraph 7, my lord.
Reliefs.
Yes, my lord, that is a larger relief. Today, my lord, I can amend my plaint also. It's not that I'm out of that.
It's not a larger relief, Mr. Thakur.
It's a different nature of relief. Very well. It's a different creature. Let's put it that way. It's a different creature. But today, my lord, kindly, since 2012, this road is in existence. They don't say that this is some encroachment which is being made today. I come to court with a case, clear case. This is part of this area. I am enjoying this area. At least since 2012, it is there.
And court also grants injunction restraining them from disturbing your peaceful possession over the suit property. Then they cannot also use that.
No,
although you admit in
kindly modify. I'm not saying that your lordship is not modified, but kindly see the nature. That is why I said, kindly specify what is the present nature, character of the property, and let status quo be made.
You have to change the character of your main prayer.
No, my lord, with the greatest of respect, perhaps not, my lord. Because prayer B, declaration that this is only
independently cannot stand. Mr. Thakur, with your legal acumen, you test that and tell us if that is independently available without a. You tell us. We rely on you. You are a senior counsel. Same footing.
I'm not equipped to deal with it now.
Same footing as court.
No, my lord. Kindly do not say that, my lord. Kindly do not
means that. On same footing. We discuss the law.
I am not.
Our
duty is to assess your.
You don't say anything against your client. No, but you represent the court also.
Yes, our duty is to assist your lordship with the right, to the best of my ability.
If you say something is law, that is law. We'll proceed on that.
It's a very onerous responsibility. May I come back on Monday?
Do that. Do that, Mr. Because we have made our doubts clear.
I follow.
You do that, and Mr. Shen will hear Mr. Shen, and then
Tuesday, if it can be done.
Yes, not difficult. But you are approaching 28th.
28th.
Well, these are
28th.
Yes,
Tuesday
is not fine.
Actually, the pleadings are complete in the interim.
Yes, that we will also remember, because if you say something anyway.
Unless it's absolutely perverse, we've learned that from your lordships.
Maybe.
That is the high test which your lordships have had.
Maybe. But we'll decide the appeal either way.
Yes.
In view of arguable questions having been raised, FMA 813 of 2026 is admitted, to be heard on the questions on the grounds mentioned in the memorandum of appeal. Push up next para. Heard the appeal in part. Push up for further hearing. List the matter on August 11, 2026. It will appear somewhat near the top because it will appear as a part-heard matter. Oh, appeals, plural. Appeals are admitted. Appeals. Memoranda.
Get one.
Thank you. Sorry, এটাও ঢুকবে বাবু এটা একটু যত্ন করে হ্যাঁ ঠিক করে রেখো Yes, Mr. Ghosh.
My appeal. Defendants number 2 to 5 are the appellants before your lordship in a suit for declaration and permanent injunction before the Civil Court at Calcutta.
Yes.
Before I take your lordship to the impugned order.
You are the plaintiff respondent?
Yes.
They're not on caveat.
No caveat. Although, my lord, we have.
If it's an injunction appeal, it's an injunction appeal. So we can ask you to, we'll admit the appeal, give them copies and we'll take up the appeal itself along with the application on Monday.
Kindly take it up on Tuesday. I should make two things clear to the court.
Is there any section 5?
No, this is a appeal from the ad interim order. Order has been extended twice. I have preferred appeals against both those orders.
So
I will give the numbers, Miller. They are not listed. They can be tagged together. May I also be allowed to use a supplementary affidavit? The competent authority has perpetrated a mischief yesterday night. The competent authority is a party to the suit. He has not,
authority under which?
Apartment Ownership Act. He has not entered appearance in the suit. His decision to merge a special general meeting with an annual general meeting has been challenged by the plaintiffs. That meeting has been held, and during the pendency of this appeal and the injunction applications before the trial court, yesterday he has passed an order nullifying a particular resolution adopted at the SGM. Now, he cannot obviously do that. It is, and I will show your lordship, not only is it patently without jurisdiction, even if he had jurisdiction, it is, he could not, the basis is completely wrong.
Put this in a
I'll
supplementary
put this in my supplementary affidavit, Millet. Kindly keep this on Tuesday so that I can serve even the supplementary affidavit on him on Monday.
Then we should keep it on Wednesday. He didn't want
Very good. Wednesday, Millet.
Who will be the advocate on record? What is the name of the advocate on record who will appear on your client?
Shomik Sarkar.
Shumit Sarkar. Shumit Sarkar is you.
Yes.
You will be the advocate on record. Very. Mr. Shumit Sarkar.
Homik shortcut, Millet.
Oh, sorry. আচ্ছা না প্রথমে হচ্ছে arguable questions having been raised, comma, the appeal is admitted to be heard on the grounds taken in the memorandum. First of next para. At this juncture, comma, Mr. Homik Sarkar appears and submits that he has instruction to appear on behalf of all the respondents.
The association and the president, secretary, and treasurer. I do not know.
Those are the plaintiffs. They are the plaintiffs.
The plaintiff's respondents, Millet.
The plaintiff.
Plaintiff. Acha, the plaintiff's respondents.
I'll also serve the competent authority, Millet. It's just right next door.
First of next para. Accordingly, let copies of the memorandum of appeal as well as the connected application be served on Mr. Sarkar, comma, appearing for the plaintiff's respondents and directly on the other respondents. Try to serve. We'll keep it on Wednesday.
It will be served, Millet. By hand.
Along with
The office is in Kiran Shankar Road.
a copy, along with a copy of the, along with copies of the supplementary affidavit which the appellants intend to file in support of the application. First of leave is granted to the appellants to file such application, file such supplementary affidavit on the returnable date.
And may it appear along with FMAT number 262 and 270 of 2026. These are the two
Just on
subsequent.
a slip of paper, write and give it. We are apprised that this is against the main order.
This is against the main order.
Since we are apprised that subsequently the order impugned in the present appeal has been extended and separate appeals have been preferred against those orders, comma, let those appeals, comma, as enumerated below, comma, be listed along with this appeal next on August 11, 2026 under the heading application. No, under the same heading. ওইগুলোতে admit করতে হবে. We'll admit those and take up for it.
Correct. Obliged.
I'm for the appellate lordship.
Yes.
Lordship, here the case is lordship, the sum and substance is lordship, two brothers acquired a property.
Right.
That they enjoyed, lordship, there was an Aposh Bontornama.
Right.
Lordship, though the Aposh Bontornama was with the plaintiff in the title suit. Thereafter, one of the brother filed a title suit for partition, lordship. It decreed to a preliminary decree. Lordship, what is surprising is that Aposh Bontornama was not a part of that suit. He never challenged that.
You have come up against the
Order 9, Rule 13.
So what was it? There was a delay in filing that?
Yes, they didn't challenge the Aposh Bontornama. They are enjoying the property. So
That was the
co-sharer.
merits of the suit you cannot hear in order 9 rule 13 appeal.
Lordship,
It was the merit of
Lordship,
the
I'm,
order 9 rule 13 application.
yes, Lordship, I'm going into further what happened, Lordship. Thereafter, the plaintiff filed for advocate commissioner, Lordship,
Hmm.
order 26, Lordship. That advocate commissioner never served any notice, Lordship. Now, Lordship, he has prepared the report, and in dark he has submitted to the court, Lordship. But Lordship, what has happened now? The common passage he has blocked, the plaintiff. He's not allowing to use the easementary rights. I've lost my easementary right, Lordship. What I am challenging is, Lordship, order 9 rule 13, unless it is restored, it cannot be examined. That report cannot be examined, and it cannot be examined as it has become evidence, Lordship. And this appos bontonoma, it has not been a part of a suit. The whole issue has been, Lordship, it has reversed. My right has been reversed for that thing.
ফাইনাল ডিগ্রি হয়ে গেছে সুটে ইন্টারঅ্যাপিয়ারেন্স করলে যদি ডিগ্রিটা এক্সপার্ট হয় তাহলে তো অর্ডার নিতে হবে। What was the delay in filing that application? When was the degree passed? That order 9 rule 13 was passed for reopening the preliminary degree. Preliminary.
Lordship, the order 9 rule 13 was prayed for setting aside the final degree, Lordship.
Final degree?
Yes.
How long after the final degree did you come? When was the final degree passed?
এটা দেখো তো, এটাতে আছে।
Court says inordinate and unexplained delay of several years from the date of final degree.
Lordship, I contested the suit, Lordship.
Final degree was passed ex parte. We are asking you, when was the final degree passed and when was the miss case filed? Where is you haven't filed any application? We require copies of those order 9 rule 13 application, objection, those things have to be there. Please bring copies of the order 9 rule 13 application as well as the written objection thereto, if any, and also a copy of the final degree or judgment.
Lordship, I oblige.
Photocopies will do, but 2 copies for 2 judges.
Lordship, I oblige, Lordship.
At the outset, we find that the appeal has been preferred against the dismissal of an application under order 9 rule 13 of the Code of Civil Procedure. Since there is no connected application, the court is handicapped in deciding the matter in hearing the appeal under order 41 rule 11 of the Code of Civil Procedure in the absence of any pleadings. Accordingly, learned counsel for the appellant is requested to furnish copies of the application under order 9 rule 13 of the code, written objection thereto, if any, and as well as a copy of the photocopy of the photocopies of the certified copy of the final decree, which was sought to be recalled by the application under order 9 rule 13, along with other relevant documents, if any, on the returnable date. Let the matter be listed under the same heading on August 10, 2026. Can you do it on Monday?
And Lordship, it will be difficult, Lordship.
So we'll put it up next Monday?
2 weeks time, Lordship.
2 weeks. 2 weeks means then 24th August.
Yes, Lordship. I'm grateful, Lordship.
On August 24th, 2026.
Lordship, I'm grateful, Lordship.
Please bring all those documents.
Yes, Lordship. It will
help you, help us also.
Yes, Lordship. I'm deeply obliged, Lordship.
Item number 9.
None appears for the parties at the time of call. Let them stand adjourned for the day.
Item number 10.
My lord, item number 10. My lord, I am appearing for the appellant My lord, I am led by Mr. Jayantakumar Mitro in this matter, my lord. My lord, he could not come to court today due to personal difficulty. My lord, may I pray for my lord?
Well,
Yes, Mr.
I have taken instructions, my lord. This is an injunction secured by the plaintiff in a suit for defamation. Their affidavit in opposition has been filed today. I understand they don't want the injunction order to stand, but things have cooled down. So my client is amenable if this order is vacated, leaving the trial court to decide. Because the trial, they filed objections. In the meantime, this was an ex parte ad interim order. So now the matters are a bit stable. The
But
in
difficult
the
is then
gush,
we have to allow the appeal. We also have to address the merits.
I withdraw it. I pray for vacating because that is my. I've seen the papers and I
Have
think
you
that
got written instructions, Mr.
I
Thakur,
will
for
take them and
your
come.
learned junior?
They've confirmed. It's better that I take instructions.
Better
Yes,
you take it and
yes.
give a copy to us. We'll keep it on record and do that.
Monday. I will pray for that the order be vacated without any expression merits, and we'll have the matter thrashed out before.
Yes, without
prejudice to any rights of either parties.
Put that in writing from your. Take that in writing from your client. Put that on record and we'll.
Yes, without prejudice to rights of either party. My rights also.
Yes, yes. Your rights first because you are withdrawing.
My lord, very well. Let them, because my lord, we have.
Don't agree to that.
No, my lord. The thing is,
You want an order on merits.
that is one thing, and number.
That is one thing.
My lord, Mr.
What are you doing?
No, Mr. Thakkar has said things have cooled down. I don't think it has cooled down.
That is not my instructions. In the light of the defamation, things are
At
the
the
title
admin
suit
it has
remains.
cooled down. It will again flare up when it goes down.
The title disputes remain, but this is a offshoot of the title.
I can give you liberty to flare up when you go down. We'll put that liberty in our order.
Very well. Very well.
A learned senior counsel appearing for an adjournment is sought on behalf of the learned senior counsel appearing for the appellants. First up, at this juncture, learned counsel appearing for the respondents, plaintiff respondent submits on instruction, that the plaintiff respondent will be willing to concede to the prayer made in the appeal, subject without prejudice to the rights and conditions of the parties in the main injunction application pending in the trial. First up, learned senior counsel is requested to furnish written instructions from his client in that regard on the returnable date. First up, let the matter be posted under the heading to be mentioned on August 10, 2026.
Grateful.
For such purpose.
Grateful. Obliged.
Grateful.
You can obtain that by Monday.
Yes. In fact, they were here. I think they just left.
Extra copies for the court also will give it.
Please.
Number 11, I am for the respondent. I
Lord, I'm for the
today, my lord.
Why?
Mr. Priyanka Sai appeared for the.
My lord, in that
I am the
case,
caveat.
my lord,
Filed for
my lord, we had filed an appeal against an interim order. My lord, that interim order has been extended, so we have filed another memo of appeal that may be
That
tagged.
number on a slip of paper. Yes. An adjournment is sought on behalf of the respondent. Full stop, learned counsel appearing for the appellant also seeks another appeal, filed against an order extending the present impugned order to be listed along with the present appeal. Full stop, next para. Accordingly, let the said appeal, bearing number ta ki ekটু দেখে বলে ওটা
FMAT 266 of 20.
দেখে টুকে নিও such and such be listed along with the present appeal under the same heading on August 11, 2026.
Copy we said.
Tuesday.
No, copy.
Tuesday.
You are on caveat.
No, my lord, not on the second.
This matter I caveat. That
Not
a copy of the you have got a copy of the can. This can.
This can
Yes.
all.
Copy of application, if any, in the other appeal, as well as the memoranda of both the appeals be served on the learned advocate for the respondent in the meantime.
My lord, if it may be kept on Monday, my lord, Mr. Arijit Vardhan is appearing in this matter.
Monday we are keeping it on Tuesday because you need they need some time to prepare on this. You serve the copies of both the memos and as well as this all the cans on them so that we can take up the appeal maybe if necessary.
Great.
Give your appearances, all of you.
I'm for the appellant in this matter. May I just?
Yes, Mr. Mukherjee.
But I'm the plaintiff in a suit for a declaration of the nature that the subsequent deeds by which the defendant had purchased the property are null and void.
because they have purchased the self-same property which my client had purchased not before. In connection with that suit, not I filed an injunction application. On contest, not the learned judge allowed not the defendant to continue with the construction, but not restrained alienation. I am agreed by the portion not by which not the construction have been allowed. But
what is the stage of the construction? What is this? Sorry, what is the stage of the construction?
That is not on record. Not only the defendant had appeared and said that we are already proceeding with the construction. That is
what is
not,
the logic given by the trial court?
Yes, your lordship will kindly have a look at the one-page order that the learned judge has passed. Not but now the query from the bench is the extent of construction.
The word of
Where from do you get this?
এই একটুখানি কাউকে পাঠাতো বাইরে কে চিৎকার করছে বারণ পুলিশ হলে পুলিশকে বারণ করে বলে যে এক্ষুনি যেন চেঁচানোটা বন্ধ করে আর একটা কথা যেন না শুনতে পাই অনেকক্ষণ ধরে চলছে জিনিসটা বলো তা না ডেকে পাঠাবো আমি ইমিডিয়েটলি যেন ওখানে চেঁচামেচির বন্ধ হয়
About the third paragraph, Lord, it is the contention of the defendant which is recorded that bona fide purchaser under registered deeds dated 2024.
Nothing, I mean, prior registered deeds.
Yes, the learned judge prima facie plaintiff has been able to show prior registered conveyances in respect to part of the property.
If he says prior, then I mean, rival claims.
But yet, not allowed, not the continue the ongoing construction. That portion I am aggrieved. I am not challenging that by which not they have been restrained from creating third party.
Understood. Yes. You have.
And I have not compared not the deed plan of not their deed as well as my deed to show not identity. Yes.
You have checked up similar.
Yes. Because I had a doubt in myself. Not
yes, you have checked that.
Yes, I have checked.
You or him will do. I mean.
No, yes, we have done that. Not that I can show before your lordship with reference to both the deeds. Not that it refers to the same lot, the plot of property.
And date obviously is prior.
Our is prior.
2018. You have filed an application for what? Stay?
But this is not as of now, not I understand not ad interim stay of not the injunction.
So the relief and only will.
If your lordship directs not, we can serve a copy and come back before your lordship.
No, will not stay.
No, I'm not asking for stay, Lord.
We'll just injunct him from.
Gautam Hada stares at my face. The judgment of I mean to say.
Although we don't know the face of Gautam Hada, neither.
But we always refer to that.
He has become, I mean, immortal. No, we'll restrain defendant number 3 from continuing with the construction.
Lordship.
In the meantime, that will.
Lordship.
The present appeal has been preferred against an order of ex parte ad interim injunction. The present appeal has been preferred against partial refusal of the plaintiff stroke appellant's prayer for ex parte. Sorry, his prayer has been allowed.
No, Lord, it was I'm the plaintiff. My injunction application
your injunction
on contest. On
Very
contest.
The present appeal has been preferred against the partial refusal of a prayer for ex parte ad interim injunction made by the plaintiff stroke appellant in a suit for declaration, specific performance, recovery of possession and permanent injunction, as well as other consequential reliefs. Who's the next para? Learned senior counsel for the appellant points out that the appellant produced prior registered conveyances in respect of part of the property, whereas the defendant number 3 also claimed title and possession on the basis of subsequent registered deeds and ongoing construction. But you purchased part of the property. So regarding the other part, he might have a right.
Lord, he has purchased Lord 7 kathas. Lord, I have also purchased 5.36 kathas.
So yours is lesser.
Mine is lesser.
So he may have some right regarding the residuary part.
He might, Lord, but
anyway,
not.
It is undemarcated. Next para,
but it is undemarcated as of now.
The learned trial judge, although observing that prima facie the plaintiff has been able to show such prior registered conveyances and that there are rival claims regarding title, possession and validity of the subsequent transfers which require adjudication at trial, despite granting injunction restraining the defendants from transferring, alienating, encumbering, and or creating third-party interest, nonetheless granted liberty to the defendant number 3 to continue the ongoing construction work at its own risk and responsibility and without claiming any special equity on the basis of such construction. Full stop. A prima facie case has been made out before us as to there being no reasonable cause for distinguishing between the two reliefs sought by the plaintiff, in view of the learned trial judge having held that a prima facie case has been made, a prima facie tribal issue has been raised by the plaintiff for hearing the suit on merits. Full stop. Next para. Accordingly, the appeal is admitted to be heard on the above question and the other grounds taken in the memorandum of appeal. Full stop. Next para. You have asked for that injunction regarding 3 only. Defendant of
But
3.
he has purchased, my lord, and the other persons, my lord, they are the partners of the defendant number 3.
So, what was your prayer in the trial court? All the defendants?
It was, my lord, in respect of all the defendants.
Very well. The respondents shall.
But I'll just check, my lord. But in the meantime, just check
Yes.
the prayers were, my lord. Yes, just check the injunction application if it was. But there's injunction page 55. Page 55, appropriate. 71 is the prayer.
Yes,
Defendants. It is defendants.
But it's anyway defendants.
Defendants.
The defendant, the respondents, and or their men and agents shall remain restrained by a further order of injunction from making any construction and stroke or altering the nature and character of the suit property till disposal of Can 1 of 2026. Full stop. The appellant shall serve copies of Can 1 of 2026 as well as the memorandum of the appeal on the respondents, indicating that the application shall next be listed for hearing in the monthly list of September 2026 and file an affidavit of service to that effect on the returnable date.
Lordship, my lord, I'm grateful.
Thanks. 13টা কল করুন করে নোট করুন। On the prayer of the appellant, let them on the prayer of the appellant, in view of the absence of the parties, the matter is adjourned for the day.
My lord, I beg to appeal.
Yes. What about state?
No, this is COLRT. Probably no caveat was there.
But difficulties, Mr. Nilanjan Bhattacharya has been assigned to this.
May I serve and come back?
No, the difficulties on the last few days back. Today we are on Friday. Yesterday or day before yesterday, yes. What is his current condition?
He's discharged from the hospital, but he is appearing online.
ক্যালেন্ডারটা মুখের সামনে রয়েছে, অনলাইন দেখতে পাচ্ছি না, ওই জন্য একটা কিছু লম্বা দিয়ে ছড়িয়ে দাও, আমার হাত যাবে না, তোমার হাত আরোই যাবে না, তুমি ছেড়ে দাও, চাও, আমারও হাত যাবে না। আর লাঠি আছে, ছোট একটা লাঠি আমার হাতের কাছে এমনিতেই রাখবো, হ্যাঁ ওটা ওটা আমাকে দিয়ে রেখো, ওটা আমার লাগবে মাঝে মাঝে, অনেক মাল্টিপারপাস ওটা ইউজ হবে, পড়ে যাবে, তোমার কাছেই রাখো, আমার হাতে রাখাটা সেফ হবে না। So he'll appear online, he's not appearing. Short pass over then.
As well. Or make it not
to the very. An accommodation is sought on behalf of the state, on behalf of the respondents, authorities, who shall let them attest and adjourn for the day. He has not come to court.
Mr. Bhattacharya, Senior Standing Counsel is there. Kindly grant a short pass.
My short pass, I will be engaged my court.
So same
Monday.
same order. Accommodation not today. Not
Monday or Tuesday kindly fixed. Tuesday. Monday my difficult.
Monday, if there is any difficulty, ask him to pray for adjournment. No difficulty. আচ্ছা ঠিক আছে করিয়ে দাও accordingly let the matter stand adjourned till August 11 2026 Tuesday.
For the private this one.
Same.
16, my lord.
You will appear?
Yes, my lord. Mr. Bhattacharya is there, my lord. My lord,
You have to have someone else also. You can argue the matter, start arguing. So you do that. Very good. Thank you, Mr. Banerjee. Yes.
But may I?
Yeah. You hadn't seen Mr. Kaur when you said. I also hadn't seen.
Sorry, I was a late entry.
No, because we encouraged him to argue himself. Mr. Niranjan Bhattacharya is the senior standing counsel. He has been assigned to this court. He's not there. He was asking for time. So we encouraged him to start doing matters. After that, we turned and saw that you were also.
I'm sure, Lord, he'll be equally
competent. He is
equally
definitely
competent.
No, we are not on his competence, Mr. Kaur. The difficulty is whether he will be embarrassed if by any chance it goes in your favor.
No,
Although
then-
Mr. Bhattacharya appearing may entail the same result, but still
I leave it to your Lordship. Lord, in case your Lordship wants to
we'll
take-
do the matter if you are ready.
my lord, my lord.
Very
I'm
good.
ready with this
Fair
one,
enough.
I'm
Fair enough. Thank you very much. Yes, Mr. Kaur. He has to start sometime. Yes.
In case there is any problem,
He
I-
argues well. Otherwise, he's good.
No, Lord, in case I'm saying that he feels any difficulty,
Fair enough, sir.
Lord, this relates to a land which the petitioner is the absolute owner. This is, Lord, measuring about 33 decimals in LR plot number 909 and CS Khatian 604. This is in Rajarhat, Lord, district, North 24 Parganas. Now, Lord, the dispute is with regard to about 22 decimals of land between the petitioner and the private respondent. Now, Lord, this land after the purchase was mutated in the name of the petitioner.
The entire 33 decimals.
Entire. After that, Lord, there was a dispute raised with regard to 22 decimal. And Lord, there were, first, Lord, the names were amended and
They
then.
claim ownership of the 22 decimals.
Yes. Now, Lord, post, Lord, the mutation, there was initially, Lord, there was a dispute as to the title in respect of these 22 decimal. Then, Lord, my name was restored in the records.
Restored means it was there.
It was there. Then it was, he applied for name to be mutated, his name to be recorded. His name was recorded. And then, Lord, I again applied for correction and my correction was allowed. My name was restored in respect of 22 decimal. Lord, we are concerned with 22 decimal. Now, Lord, post that, there was a conversion which was allowed in my favor. And Lord, from that, there was an order, there was an appeal preferred to the appellate authority. I request your Lordships to kindly, Lord, come to page 24. Lord, this is the background I am giving your Lordship, but main question is, Lord, whether, Lord, the LRTT could have admitted the petition without, Lord, exhausting the appeal. This is the short point, but I just want to show your Lordship because, Lord, the matter was remanded by the appellate authority in the earlier round.
So an appeal was preferred on the...
Appeal was preferred. It was remanded by the appellate authority.
The private respondent has preferred this appeal now.
Yes.
Before the tribunal.
Before the LRTT.
And it was him that previously filed that appeal.
Yes. And Lord, this appeal succeeded. It was remanded. The remand order has gone directly to, from the remand order, it have got directly to the LRTT.
If that is the gamut of this, Mr. Ghosh, what do you say? An appeal lies, you preferred an appeal previously, that it is that forum which remanded.
My lord, by invoking the provision of 10(3)(b, I approach before the learned tribunal. My lord, initially, my lord, what my learned senior friend says, my lord, some facts are, my lord, not.
এটা চলবে না, এলআরটিটি অ্যাক্ট যেটা আছে সেই ল্যান্ড রিফর্মস অ্যাক্ট, ল্যান্ড রিফর্মস এর টেনেন্সি ট্রাইব্যুনাল আগে আগে ল্যান্ড রিফর্মস অ্যাক্টে কথা লাস্ট এলআরটিটি অ্যাক্ট আছে।
Yes, it is at the end. This
in the
land
that
reform,
book, yes.
land reforms act শেষে
যে কোনো ল্যান্ড রিফর্মস অ্যাক্টই ওটা শেষে আছে, মানে যা ছিল তাতেই আছে। ওটা পাঠিয়ে দিয়েছো, নতুন বই না আগেকার, তো ওটা জানি না উনি কেন, আমার চেম্বারে কিছু থাকে না তো আমি পাঠিয়ে দিই। কাপুর সাহেবের চেম্বারে কি করে গেল, আনিয়ে না উনি কেন, লাগবে তো। Challenge to the restoration in your name.
Yes. Kindly, my lord, see the middle paragraph.
Yes.
Only the mutated area of 22 acres of plot so and so, Moja so and so is the matter of consideration in the instant appeal.
Right.
Then, Lord, the submissions are recorded. Then your lordships will kindly come to the next page. I'll just keep the merit of the matter, just to kindly see the last paragraph. Considering all the issues involved in this case, I am of the opinion that the mutation in the name of the instant respondent, number 1, against plot number such and such 22 acres was not done properly. I do not take any consideration for the rest plots. I am also of the opinion that the matter of recording of plot number 909 with area of such and such needs to be reviewed afresh. Hence, it is ordered that the matter is being sent back on remand to BLLRO Rajarhat to reconsider the same on the basis of the following issues. Then, Lord, the 4 issues are framed.
Yes.
Now, Lord, it goes to the BLLRO.
Justice Calcutta.
Now,
yes,
page 32. Lord, since we are not concerned with the merit of the matter,
right now.
33, if your lordships kindly come to. Your lordship sees the last paragraph. Now the learned appellate authority remanded back the instant case with the following issues. Then, Lord, point number 1 and 2, he decides. Your lordships may kindly come to the next page. Point number, the points are taken. Other relevant fact, then he says recording of Snowflower Sales Private Limited under LR Khatian by mutation case before final publication LR record had not been challenged here. In the light of the aforesaid discussion, it is to be stated that there is no cogent reason found for record correction in favor of the applicant in this instant case. Thus, the prayer of the applicant is disallowed and disposed of, and the order of the appellate authority is complied with.
No,
Certified
the
copy.
applicant means they were the applicants.
They were the applicant, yes.
So initially it was mutated in your name totality.
Yes.
Then their name was recorded in 22 decimal
Correct.
Then your name was restored.
Yes.
After that they filed another application. This
No.
application.
I see. I stand corrected. Recording of our name, mutation of our name was challenged. I stand corrected. There was no restoration. The mutation itself was challenged. I stand corrected.
All right.
Mutation itself was challenged. Then Lord,
so this is now after the one, this is rejected.
This is rejected. Now, Lord, your lordships will kindly see the impugned order of the tribunal, which is Lord the law at the towards the end. Certified copy is there. Lord, your lordships will see the ground on which Lord the tribunal interferes.
Yes.
If your lordships Lord kindly come to the first page, it says, upon hearing parties considering material on it appears that the maintainability of the present original application has been questioned by the respondent on the ground that an alternative statutory remedy of appeal is available. Under the West Bengal Land Reforms Tenancy Tribunal, the respondent argues that in view of 10(3)(a) of the tribunal ought not to entertain the application. However, the applicant submits that although ordinarily an appeal lies, the instant case fairly attracts the exception under 10(3)(b) of the Act. It is submitted that the matter had earlier travelled before the appellate authority, whereupon appeal case number such and such was disposed of with a specific remand direction with the BLRO, Rajarhat, etc. Despite such direction, BLRO has passed the impugned order in law case number such and such without addressing the issues identified in the remand order and without proper adjudication. The applicant further submits that he is undergoing cancer treatment and compelling him to once again undertake appellate proceedings would amount to grave hardship and denial of effective justice. So now, Lord, kindly have a look at section 10(3)(b). This is the only ground.
Yes.
Ache, Judge section.
No, we are sharing this. We have seen. Yes.
Lord, B says remedial measures available under the provisions of the relevant specified act are not adequate or shall cause undue hardship to the applicant.
I don't know. Yes,
So, Lord,
seen it.
there are two grounds. Its remedy is not adequate or shall cause undue hardship to the applicant. Now, Lord,
so he's cancer patient. He's a cancer patient. That is. এই ডেকে পাঠাতো যে আছে যার গলা শোনা তাকে ডেকে নিয়ে এসো কোর্টে নিয়ে এসো তাড়াতাড়ি যাও তাড়াতাড়ি যাও
ঠিক আছে
কার গলা পাচ্ছিলাম ওখানে কার গলা ছিল আপনি চিৎকার করছেন কেন
কোথায় অ্যাপ্লিকেশনটা
কিছুক্ষণ আগেও শুনলাম কোর্টটা চালাতে তো অসুবিধা হচ্ছে আপনি অন্যদিকে তাকিয়ে আছেন কেন আপনি অন্যদিকে তাকিয়ে আছেন কেন এদিকে আসুন এদিকে আসুন এখানে আসুন চিৎকার করছেন কেন আপনি চিৎকার করছেন কেন আপনি ওনার সঙ্গে আছেন আপনি কেন ভুলটা করছেন আপনি একটু বলতে পারেন না ওনাকে বলুন আর যেন না হয় কোর্ট ডিস্টার্ব আর একবারও যদি হয় কিন্তু আপনাকে ওনাকে দুজনকে অ্যারেস্ট করা হবে যান
Now, my lord, the hardship which the tribunal saw was about the cancer, a person suffering from cancer.
Yes.
Your lordship kindly comes to page 38 once. There are 6 applicants.
Yes. 6.
There are 6 applicants.
Oh, the others could have.
Tribunal. Now, blood that apart. This hardship, which is not mentioned in this section.
That equally applies to the tribunal also. I mean, if he goes to the tribunal, one forum less, but that cannot be a rider for.
But this hardship, Lord,
reducing forums. I mean,
absolutely, that can't be a ground.
Then that by that logic, it could have directly gone up to the Supreme Court also. Yes, Mr. Ghosh. You want to add anything, Mr. Scott?
No, Lord,
in reply, you may add if you will.
No, our High Court has dealt with this issue. There has been several judgments on the interpretation of this 10(3)(b).
What do they say?
The court says that if there is no efficacious remedy,
yes,
then of course,
if the tribunal is not functioning,
and the hardship is also relatable to the tribunal, to the appellate authority being not available or not hearing, pendency, the immediate urgency which can't be addressed. These are
availability of that remedy for some reason.
Yes, these are held to be analogous, Lord, grounds.
Yes,
If your lordships kindly see, they are held to be analogous.
Remedial measures available under provisions are not adequate or shall conflict. Yes. Remedial is connected with remedial measures not being available.
Available.
Very
That's
right. Yes.
The original owner of the property, I purchased the land.
No, we are not on the merit.
No, why?
Whether it is maintainable.
What? Prior to that, land expense says he is the owner of the.
We are not taking into consideration.
Our name was recorded in the record of rights after
maybe, but why? What
regarding that, I am coming. Prior to that, kindly comes to page 95. Our records now, kindly comes to 170. After passing of this order, my learned friend appear before this honorable tribunal, prayed for filing affidavit in opposition and contest this matter, and the date has been fixed on 14th October. Now, Maladi, why Maladi I approach before the learned tribunal?
Why?
First, I cannot go like a ping pong ball. This is the second round of litigation. My name has been.
The law contemplates that you have to go like a ping pong ball. You cannot travel like a football. You have to go like a ping pong ball only. Law provides a particular forum. How can you bypass that just because of the element?
That is
then you could have directly come up before this court.
No, that is the learned tribunal. That our honorable.
It's not maintainable after affidavit in reply and opposition. This question again, this will crop up at the final.
Why in the first round of litigation, appellate authority give a direction to the fact finding authority to decide the issue on that point.
Right.
The deed, our deed is of 1979. Now their deed is 2006, and our records pen in our name. After filing of this original application, they filed a civil suit. Earlier occasion one.
Whatever happened, your remedy against that order after demand, your application has been rejected. There is a specific remedy under section 54. Why didn't you avail that? We don't find any ground of hardship here. The ground that you have taken. Respondent number 4 sealess. What about the other respondents? They could have taken up.
No, that is the respondent number.
Sorry, not respondent.
Applicant. One of the applicant is
respondent 1. No, respondent 1 is state. Which of the respondents?
Here one of the applicant.
Here they must be respondents. So which respondent here?
Respondent number 4 here.
So 4, yes.
Yes. Respondent number 4 is.
What about the others? They could have come up.
This is the joint property. Now, kindly consider, kindly direct, the issue, regarding,
they does not lie directly before the tribunal. Both of you will lose a forum of challenge.
In earlier litigation, the matter was the earlier occasion was heard by the appellate authority. Now, appellate authority.
If you want some variety now.
Now, kindly comes the appellate authority specifically stated the recording in our name, deleting our name was erroneous. That findings is there. for the reasons the matter demand for the fact to the fact finding.
How does it justify your going to the tribunal? Whatever you are saying, you could have canvassed before the appellate authority. It is the appellate authority with remanded, which you approached on the earlier occasion. You have to go there only. We don't find any hardship here.
Only hardship the two grounds I approach. First the earlier occasion kindly see the appellate authority's order again.
What is that ground? Tell us.
Ground the earlier occasion we approach regarding this issue, appellate authority found that the deletion of our name from the record is erroneous for the reasons considering our deeds and possession to decide the issue. Now in the remand hearing, the appellate authority without following the direction passed by the appellate authority
That's why you go to the tribunal. That's a ground for going to the tribunal instead of the appellate authority.
Now this is one of the hardship if I.
What is the hardship?
And the
appellate authority remanded to the BLLRO. BLLRO, according to you, passed a wrong order after that, after remand. So you prefer the challenge directly to the tribunal. How is that a hardship?
No, the hardship the one of the applicant before the
was suffering from a terminal illness. That is the only hardship we find and considered by the trial court, by the tribunal. The appellate authority remanded, an order was passed against you. How are these hardships?
Now
you are not going to the tribunal.
Now subject to my lord consideration, they my lords can fix a date. In the meantime, matter can be disposed of on that day. In the meantime, give a direction for filing affidavits. I shall also file a reply.
Both of you lose a forum, Mr. Suresh. We can't permit that. We'll ask Mr. Kaur. Yes, Mr. Kaur, what about you have participated there?
Not participated, but for taking directions. But if the affidavit is filed there, again the same point will come.
But they prayed for time.
But in fact, we have
didn't say that
paragraph 17. I have said that, Lord, losing a forum, Lord, I have never assented to the losing of forum. The advocate was there. The date was fixed. The advocate appeared. Paragraph 17, Lord, I have explained. 17 and 18, Lord, are the pleadings. The issue is not an order which is passed by the tribunal invoking power under 10(3)(b). Whether that was a proper invocation or not, it's a legal issue.
Yes. The present challenge has been preferred against an order whereby the learned tribunal, whereby the West Bengal Land Reforms and Tenancy Tribunal entertained a challenge against an order passed by the concerned block land and land reforms officer, who's up learned senior counsel appearing for the petitioner, argues that the order of the BLLRO was passed on remand after the matter was sent back by the appellate authority, in connection with an appeal filed on an earlier occasion by the private respondents themselves under section 54 of the West Bengal Land Reforms Act 1955, which of next para, however, upon being apparently aggrieved by the order passed on remand by the BL and LRO, the respondents chose a shorter path this time, by taking out a challenge against the order of the BL and LRO directly before the tribunal, bypassing the appellate authority, which is stipulated under the statute. So, sub next para, learned senior counsel submits that the tribunal considered the suffering of one of the applicants before it, within bracket present respondent of 4 bracket close, from a terminal illness as a ground of double inverted undue hardship as contemplated in section 10 within bracket 3 within bracket small b of the West Bengal Land Reforms and Tenancy Tribunal Act, 1997. However, learned senior counsel argues that the undue hardship double inverted contemplated in the said provision is inextricably tied up with the previous portion of clause small b, that is, where the remedial measures available under the provisions of the relevant specified act are not adequate. Full stop. Next para. Learned Senior Counsel submits that although subsequently affidavits have been filed, time has been sought by the appellant for filing affidavits before the tribunal, no assent at any point of time was given to the tribunal assuming usurping the jurisdiction of the appellate authority, thereby depriving the parties to a forum of challenge. So next para, learned counsel appearing for the private respondents. Moreover, it is pointed out that even if the respondent number 4, one of the applicants before the tribunal, is suffering from such illness, nothing prevented the other applicants stroke respondents, private respondents, from preferring the challenge or conducting the same before the appellate authority. So next parallel counsel appearing for the respondent, private respondents contends that the ailment of the respondent number 4 herein was sufficient within double inverted hardship, double inverted clause, to justify the order of the tribunal. Furthermore, it is pointed out that subsequent to the impugned order, the present appellant, present writ petitioner, participated before the tribunal in the proceeding before the tribunal and sought time to file affidavit in opposition, thereby submitting to the jurisdiction of the tribunal. So it is contended that thereafter, therefore, the writ petitioner cannot now resile from such position and turn back on its participation by challenging the order whereby the tribunal held that the application before it was maintainable. Next para, upon a perusal of section 10 within bracket 3 within bracket small a of the 1997 Act, we find that under normal circumstances, a challenge before the tribunal shall not be admitted at all unless the tribunal is satisfied that the applicant has availed of all remedial measures available to him under the relevant specified act. Full stop. As an exception thereto, clause small b within bracket of subsection 3 provides that the remedial measures available under the provisions of the relevant specified act, where not adequate or causes undue hardship to the applicant, the tribunal, if satisfied on such count, may permit the application to be filed even without all remedial measures being availed. Full stop. Next para, even if we proceed on such presumption, it is evident from a plain reading of clause small b of subsection 3 of section 10 that the undue hardship, double inverted undue hardship envisaged in the said provision is connected with the prior portion of the provision, which stipulates that that the tribunal will entertain an application if satisfied that the remedial measures available under the provisions of the relevant specified act are not adequate. Full stop. By use of the expression or double inverted clause between the two parts of clause small b, it has been clarified that the undue hardship contemplated therein is directly linked with non-availability of remedial measures, which under the said provision, may not be either adequate or may cause undue hardship for the tribunal to entertain such application. So next para, thus, in the present case, the ailment, the serious ailment of one of the applicants could not furnish sufficient cause for the tribunal to give a go-by to clause small a of section 10 within bracket 3 of the 1997 Act. Full stop. Next para. In fact, the ailment of the said applicant, if a deterrent to go before the appellant tribunal, would have equally applied in appearance of the said applicant before the tribunal as well. Full stop. Next para, mere ailment of any nature cannot be sufficient justification to permit a party to skip or jump a forum altogether, comma, although the law specifically contemplates such forum. Full stop. Next para. Secondly, comma, in the present case, comma, there were several other co-applicants with the uh, concerned applicant within bracket present respondent number 4 bracket close who is suffering from the said ailment. Full stop. Next para. Thus, comma, in the absence of any explanation as to what prevented the other co-applicants to prefer the challenge, even if respondent number 4 was ailing, comma, the tribunal also erred on such count in entertaining the application at all. Full stop. Next para. Insofar as uh, alleged participation of the writ petitioner before the tribunal after the impugned order was passed, comma, we do not find that at any point of time the writ petitioner has considered or submitted to the jurisdiction of the tribunal by participating in the hearing of the matter on merits. Full stop. Rather, comma, only an adjournment was sought to file written objection, comma, in which the writ petitioner could very well have incorporated the plea of maintainability as well. Full stop. Next para. Hence, comma, we find that by the impugned order, comma, the learned tribunal has deprived both parties of one forum of challenge, comma, which runs contrary to the scheme of the 1997 Act itself. Full stop. Accordingly, WP LRT 99 of 2026 is allowed on contest against the allowed on contest, comma, thereby setting aside the impugned order dated December 15, 2025, passed by the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 2975 of 2025 within bracket LRTT, and comma, consequentially all subsequent orders passed in connection with the said original application. Full stop. Nothing in the above order shall preclude the private respondents from preferring a challenge before the order of the BLLRO, which was impugned before the tribunal, comma, if so otherwise entitled in law, comma, before the appropriate appellate authority. Full stop. No rest to cause urgent settlement.
Only one thing,
Affidavit size shall to be kept on record. Yes.
only got one thing, the
Yes,
appellate
allow
authority
for
may be
this.
directed to expedite the appeal.
First file it. No.
But I shall file within 1 month.
Before filing, we won't. They are also human beings, Mr.
I beg to appear on behalf of the petitioner. My lord. My application with an was prior for expeditious disposal of the pending original application before the learned first bench. my lord.
MA is also pending. What is
No,
the
no,
MA?
no. The present MA was for expeditious disposal. That was disposed of by the learned tribunal without passing any effecting order, my lord. My lord, we have paid for expeditious disposal on the view of the present age and the present health issues of the petitioner, my lord. But the learned tribunal did not address on those issues, my lord, only dispose of this matter, my lord.
Yes, what-
Only seeking for, my lord,
Yes, what
No, no, regarding early disposal, I have not, but only one thing was the respondent number 13 and 17 one of the expired.
Yes, lordship.
Expired?
Expired, my lord. Their names have been expunged.
No, 13 and 17. 13 and 17. Expunge in name in respect of other respondents.
I will expunge those that
No, their heirs are
respondent before the, my lord.
their heirs are on record. Before us also we cannot pass order in the name of a deceased person.
Lordship, this has come to our knowledge after we served the copy of the petition, and those have
Understood, but we cannot pass orders in the name of a deceased person. You have to effect substitution. Formally, you have to effect a substitution.
before this honorable court, my lord.
Yes, our order will be in the name of a dead person. What are you saying?
I will.
Since
If
it is
your lordship grants us leave,
since
my
it is
lord,
pointed out that respondent numbers 13 and Mr. Ghosh,
13 and 17.
13 and 17 have died in the meantime, comma. Leave is granted to the petitioner to file appropriate application for substitution. Push up. Liberty is also given to the learned advocate on record for the petitioner to mention the substitution application to be tagged along with this matter when the same next comes up for hearing. Push up. Let the matter be listed next. How soon can you file your substitution?
by my lord, what time? Because I
Will-
have to gather the name.
You also supply the names if you can.
Not here and now I am substituting.
Very well. Listed on August 24th, 2026. Affidavit is filed to be given. 24th August, we are putting it.
Great.
Monday week. So if they supply, immediately file that application, have it mentioned, and when you mention, just indicate that it is to appear on the with the main matter, which is due to appear on 24th.
Grateful. Great.
In this matter, I expect for the private response.
My lord, I forgot the petitioner. My lord.
Kindly see the order. It starts from page 73,
My lord,
operative
first
part
of all,
75. Kindly see the order.
affidavit of service. My lord,
Yes.
first of all,
75. Relevant.
my lord, I give, my lord petitioner and the respondent number 5, he is full brothers. Father of the petitioner gifted this property being deed number 1225 in the year 1975. After 8 months, 8 years, another gift deed was prepared by this younger son, 1470 of 1983, in the year 1983, my lord. After 8 years, my lord, according to Transfer of Property Act, my right is already vested. After that, my lord manage the petition, the respondent to by his name in the mutated his name. And it was-
Their gift deed is subsequent.
My lord,
Their gift deed is subsequent.
subsequent 2 times the gift deed was prepared, my lord.
That has been challenged by way of title suit. May I kindly see the observation. If
Yeah.
the title suit is not
No,
decided,
Their gift
DLR
deed is subsequent to your gift deed.
Yes, my lord. Not subsequent, but previously I was executed this property, the gift deed, my lord.
What is the meaning of subsequent?
Purvabhati.
Parabharti.
Yes, my lord.
What is the meaning of previous?
Purvabhati.
So if your gift deed is Purvabharti, isn't there Parabharti?
Yes. Yes, my
Our
lord.
question is whether their gift deed is subsequent to yours. You say no, your gift deed is previous to theirs.
Yes, my lord.
Let us see the appellate authority's order.
Appellate authorities order.
My lord, kindly see the appellate authorities order.
Which page?
My lord, I am.
73, my lord. DLRO set aside the order of BLRO and revert his.
It was mutated in whose name? Their name?
Yes, my lord.
You asked for cancellation of that mutation and your name to be recorded.
Yes, my lord. My father's name was reverted according to the DL and LR order.
What did you ask for before the BLLRO?
My lord.
My lord could not be your question. What did you pray for before the BLLRO?
Order, my lord, kindly the appellate authorities order, page 36.
BLLRO adjudicated on your application or their application?
No, my lord. Against my application.
Your application was for what?
My application was in DL and LR, my lord.
আপনি বিএলএলআর কিসের জন্য দরখাস্ত করেছিলেন? বিএলএলআর কাছে?
আমি করিনি, my lord.
ওরা করেছিল।
ওরা করেছিল।
কি জন্য করেছিল?
ওরা মিউটেশন করার জন্য।
ওদের নামে মিউটেট করার
হ্যাঁ
জন্য।
স্যার।
তখন আপনি অ্যাপিয়ার করেছিলেন, আপনাকে হিয়ারিং দেওয়া হয়েছিল বিএলএলআর কাছে?
আমাকে কোনো
বিএলএলআর ওদের অ্যাপ্লিকেশন অ্যালাউ করে মিউটেশন ওদের নামে করে দিয়েছিল। তার এগেইনস্টে আপনি অ্যাপিল করেন।
ইয়েস মাই লর্ড।
অ্যাপিল এখন আপনি ইংরেজিতে বলছেন, তখন বুঝতে পারছিলেন না। ইয়েস মাই লর্ড। ডিএলএল এর কাছে যখন আপনি অ্যাপিল করলেন তখন দুপক্ষ শুনে আপনি বললেন যে আপনার গিফট ডিডটা আগের, সুতরাং ওদের নামে হতে পারে না মিউটেশন।
ইয়েস মাই লর্ড।
তা ওরা তখন ডিএলএল আপনার কথা শুনে অ্যালাউ করে দিলেন অ্যাপিল?
না মাই লর্ড, আমার বাবার নামে ট্রান্সফার করে দিয়েছে।
বাবা তো মারা গেছেন।
না, বাবার নামে যেহেতু আগে বাবার নামে মিউটেশনটা ছিল,
ডিএলএল বাবার নামে ট্রান্সফার করে দিয়েছে?
নো ডিএল নয় মাই লর্ড, আমার বাবার নামে।
ডিএলএল বাবার নামে কি করে হবে? আপনার বাবার নামেই তো হবে।
ইয়েস মাই লর্ড, রিভার্ট করতে বলেছে।
You please help us out of this conundrum.
The appellate authorities order, my lord, page 36, kindly see.
36?
36. In their applications. There are 3 appeals in one order. Appeal case number 1795, 1796, 1797.
So this arises, they challenge your application for mutation was allowed?
Allowed.
From the name of a father to your name?
Yes.
They challenged that in this appeal?
Yes, my lord.
Very good.
And my lord, the observation was that.
Oh, sorry, why so many appeals? Several
so many
plots?
appeals, the analogous matter. That
why? Because several plots were there?
Several plots were there. There are so many plots, my lord.
Yes.
That's why, my lord, this appeal. Separate appeals.
You are Khabirul Islam?
No, my lord, I am for the, my lord, the Satyananda Laha.
Khabirul Islam was the advocate.
Yes. Satyananda Laha, respondent
so
number
before
5.
The DLLR, you are the private respondent?
Yes.
You are Satyananda?
4 mutations cases were there.
You are Satyananda?
Yes.
And they are Vivekananda?
Vivekananda.
But DLLR has not decided title.
Yes, that's true.
Has not decided title.
No.
There are 2 deeds.
Yes.
DLLR says the prior deed will prevail.
Yes.
And on the basis of that has passed an order. But then the tribunal was wrong.
Tribunal, my lord, kindly see, this is the title suit is pending and injunction order was there. That's why, my lord, the honorable tribunal has said that the suit will decide whether this gift deed
title should filed by them or you?
By them.
You, no, my lord.
By them as well as but there are.
I am not in title suit. They are in title suit.
Please check up. Please check up whether whose suit.
Title suit, my lord. They filed title suit.
Private respondent, sub is a private respondent filed a title suit. Private respondent is no. You preferred the appeal before.
Yes.
Private respondent was you. You submitted that you had filed a suit.
Yes.
You come to the impugned order of the tribunal.
Impugned tribunal.
No, they come to the impugned order. Come to the impugned order.
impugned order of a tribunal, my lord.
Please come there. The order which you have challenged in this writ petition, that order of the tribunal, please come there. It should be at the last, at the end.
75.
Please come to internal page 2 of that. Internal pagination is at the bottom.
75.
Internal page 2 you have found?
Title suit is filed, then the matter shall be decided.
No, before that paragraph.
Moreover, from the order sheet of the appellant authority, it reveals that learned advocate of the private respondent submits that the private respondent filed a title suit being numbered. My lord,
You are the private respondent.
I am at that time was a private respondent.
Before the
but-
tribunal,
but
you were the
my lord, I once that in some time
See,
I shall collect.
You submitted that private respondent filed a title suit against applicant.
Yes.
They are the applicant, you are the private servant. Therefore, you have filed the suit.
My lord, kindly appreciate, my lord. My lord, I once kindly give some liberty and to collect the order, but learned advocate, learned judge passed this order. Kindly give me to collect the authority concerned to collect this order, my lord.
এখানে লেখা রয়েছে আপনার উকিল বাবু বলেছেন যে আপনি সুটটা ফাইল করেছেন, আপনি প্রাইভেট রেসপন্ডেন্ট ছিলেন ট্রাইব্যুনালে।
Yes, my lord.
ঠিক আছে, এবার প্রাইভেট রেসপন্ডেন্ট যদি ফাইল করে থাকে সুট, তার মানে আপনি বলেছেন যে আপনি সুটটা ফাইল করেছেন।
আমি মাই লর্ড আমি বলেছিলাম ওখানে যে আমাকে সময় দিন একটা
এখানে বলা হচ্ছে সেটা বলা নেই, বলা হচ্ছে আপনি সুট ফাইল করেছেন, তার নম্বরও দিয়েছেন।
ইয়েস আমি কালেক্ট করতে চেয়েছিলাম যে ডকুমেন্টস গুলো।
কিসের কালেক্ট করবেন? কি কালেক্ট? আপনার সুট আপনি কালেক্ট করবেন?
My lord, order impugned order. They said the impugned order was passed.
ইমপিউন অর্ডারের কথা বলছি, সব ইমপিউন অর্ডার তো এখানে অ্যানেক্স রয়েছে।
My lord, this is the impugned order of DL.
আরে ইমপিউন অর্ডারে লেখা রয়েছে যে আপনি বলেছেন আপনি সুট ফাইল করেছেন ওদের বিরুদ্ধে।
My lord, may I give some time
No.
to collect the order?
No.
To collect the order, my lord, and I produce before your honor.
The present challenge has been preferred against an order passed by the tribunal whereby the tribunal observed tribunal set aside the order of the appellate authority on the ground that a civil suit was pending at the behest of the private respondent before the tribunal, comma, that is the present writ petitioner. Puts up next para. The short backdrop of the matter is that initially the subject plots were recorded in the name of the father of the private parties, late Goyanath Laha.
Yes.
Full stop. On the prayer of the private respondent herein, comma, the concerned block land and land reforms officer, comma, subsequently mutated the properties in mutated the plots in the name of the private respondent on the strength of a gift deed of 1984 executed by the said late Goyanath Laha in favor of the present private respondent Sotyananda Laha. Full stop. Next para. Being aggrieved therewith, thereby, comma, the learned the writ petitioner preferred a challenge before the preferred an appeal before the appropriate appellate authority, that is the district land and land reforms officer, comma, Birbhum, under section 54 of the West Bengal Land Reforms Act 1955. Full stop. The said appeal was allowed by the DL and LRO by placing reliance of an earlier gift deed of 1974 executed by the self-same donor in favor of the writ petitioner Vivekananda Laha. Full stop. While doing so, comma, the district the DLLRO came to the finding that in view of the earlier gift deed executed by late Goyanath Laha in favor of the writ petitioner Vivekananda, comma, the subsequent gift deed of 1984 in favor of the private respondent Sotyananda did not convey any title to the property in favor of the private respondent, and accordingly reversed the observation order of the BL and LRO, comma, directing the mutation proceeding to be heard afresh, considering the earlier gift deed in favor of Vivekananda Laha. Full stop. Next para. The present private respondent, being aggrieved by the said order of the appellate authority, preferred the challenge before the tribunal, which was disposed of by the impugned judgment. Full stop. The learned tribunal took note of the submission of the present writ petitioner that he had filed a title suit bearing number 252 of 2025 against the present private respondent, with regard to the self-same property, where the validity of the two gift deeds of the rival gift deeds of the parties was under contention. Full stop. On such premise, the learned tribunal observed that since the title suit is pending, the matter can only be decided by the civil court, and unless and until so adjudicated, the quasi-judicial authority, that the appellate authority ought not to have interfered in such respect. Full stop. Next para. Learned counsel for the petitioner submits that in view of the earlier gift deed in favor of the writ petitioner, the DL and LRO was justified in directing consideration of the said document and for the BL and LRO to pass appropriate directions for mutation. Full stop. Next para. Learned counsel for the private respondent controverts such submissions and argues that since the present writ petitioner himself has preferred a title suit which is now pending, the matter is sub judice before the civil court, and the learned tribunal was justified in setting aside the order of the DL and LRO, awaiting the adjudication by the civil court. Full stop. Next para. In the present case, we find that it is the writ petitioner who has himself preferred a challenge in respect of the title of the parties, on the basis of the dispute as to the rival gift deeds executed by the father of the private parties, respectively in favor of the writ petitioner and the private respondent. Full stop. Next para. Thus, the matter is now sub judice before a competent civil court, which is the only authority vested in law to adjudicate the title of the parties. Full stop. In the event there was no title suit pending, the BL and LRO still might have been empowered to look into the two deeds and pass orders of mutation accordingly. Full stop. However, since the matter is sub judice, before the civil court, that too at the behest of the petitioner himself, unless and until the civil court adjudicates the issue finally, it would be beyond the scope of the BL and LRO to decide such title, which would then be necessary for passing appropriate orders in the mutation proceeding. Full stop. Accordingly, there is no scope of interference with the impugned order of the tribunal. Full stop. However, we make it clear that in the event the writ petitioner ultimately gets a decree in his favor from the appeal from the competent civil court, it will be open to the writ petitioner to approach the concerned BL and LRO for mutation of the property in his name on the strength of such decree.
My lord, kindly revert the father of the.
Next para. In view of the above observations, WPLRT 123 of 2026 is dismissed on contest, thereby affirming the impugned judgment dated January 9, 2026, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal in OA number 3264 of 2025. No orders to cause, urgent certified copies. Prathame affidavit service. Thank you.
Same matter, 4. Same status suit 1 or 4 mutations case and 4 file 4 writ petitions. Analogous.
Oh, acha, the next ones.
Yes. Up to 19, 20,
Dekho, board dekho. Up to 21.
21.
Same order. এগুলোতে একটা দেখিয়ে একটাকে কারেক্ট করে দিলে কপি পেস্ট করে দিন.
Yes. Only case number is different.
Yes, case numbers will be different, right?
Case number only different. Different.
কেস নাম্বার বলে রেফার করিনি, অ্যাপিলেট অথরিটি বলে করেছি। না WPLRT নাম্বারটা আর অ্যাপেলেট অথরিটি কিছু করিনি দেখে নেক্সট
My lord, I beg to appear for the petitioner, my lord.
Yes.
My lord, it's an application my lord, seeking preponing of the date, my lord, filed before the tribunal. My lord, the difficulty is, my lord.
Yes.
The in the original application, as per the
What about service on the state?
State served. My lord, the private respondent filed the original application.
What about his service?
My lord, in the at the address given in the cost title of the original application, in that address we have served. It says, my lord, insufficient address.
But it is his application, original application?
Yes.
We'll take that. Yes. একটা order record করো, affidavit of service filed to be kept on record. Although the state has been served, comma, the postal article sent to the private respondent has returned with the endorsement insufficient address. However, comma, since the service was sought to be effected at the address given by the private respondent himself in the original application from which the present writ petition arises, comma, we deem the same to be good service and proceed to take up the writ petition for hearing. You are for the private respondent?
The state respondent led by Piyush Chaudhary.
Led by?
Mr. Piyush Chaudhary.
Yes, yes.
My lord,
preponing the date.
Preponing the date, my lord, the maintainability point was raised. My lord, with since the appellate authority, my lord, held that on the self-same issue by the same applicant filed suit seeking cancellation of my deed and my lord seeking declaration of his title.
Yes.
The appellate authority held that on the self-same issue, since the seeking cancellation of the deed already pending, we the appellate authority is not the competent authority to decide the issue. So appeal rejected. Against that, my lord, the applicant being the private respondent preferred the original application before the tribunal. We address on the same issue twice. My lord, the matter was adjourned on the ground of maintainability and next date has been posted on, my lord, 24th February 2027.
What was the miscellaneous application? MA, which was this?
No, কোথায় MA নেই?
19th January order?
Oh, yes. Oh, that was, my lord, he in the application, he said not within the application, but it was virtually within the period of limitation. That for correction, my lord, that application was filed.
So maintainability point still remains open?
Yes.
Very good. In view of the innocuous nature of the prayer, comma, no further service is directed on the private respondent. The writ petitioner has, the private respondent has filed original application number 2206 of 2025 bracket LRTT, in which an objection as to maintainability of the same was taken by the present writ petitioner. Next para, writ petitioners. Next para. However, comma, the matter is being adjourned inordinately, comma, the last such occasion being on May 5, 2026, comma, when the original hearing on the point of maintainability was adjourned for more than 7 months, comma, till February 24, 2027. Next para. We find that such inordinate delay in preferring the inordinate delay in disposing even the maintainability issue is adversely affecting the interests of justice as well as affecting the right of the parties to get free easy access to justice. Hence, comma, WPLRT 132 of 2026 is disposed of by directing the 4th bench, comma, West Bengal Land Reforms and Tenancy Tribunal to dispose of OA 2206 of 2025 within bracket LRTT upon first taking up the issue of maintainability as expeditiously as possible, comma, positively within 6 months from the date of communication of this order to the learned tribunal. It is made clear that for the purpose of implementing this order, comma, the learned tribunal shall shift back the date and fix earlier date for hearing on the issue of maintainability. No rest to cost charges.
My lord, 6 months will take us to this February, my lord.
Yes, it has been fixed on February.
My lord, if when my lord directs, my lord, within 6 months, it will take
No,
us
if it is the maintenance point is held in your favor, then it goes.
Lord,
6 months is the outer limit for deciding the matter, even if it goes against you.
Yes, true, my lord. If the date may be, my lord, preponed, my lord.
6 months. Next.
As well.
রাখুন আপনি।
6 months এর মধ্যে complete করে দিতে হবে।
Yes.
Complete করে দিতে হবে।
I'm filing my affidavit of service.
For the state test. You are for the private test? Oh, she's with you. You are for the private test? Yes. Yes, please. You take your seats, all of you. Well, just here. No seat.
My lord, my lord, the subject matter in challenge, but the order in challenge is the order passed in the section 5 application.
Rejected.
My lord, we are the private respondents.
Section 5 allowed.
Yes, section 5 has been allowed, my lord. My lord, that has been challenged before here, my lord. If my lord takes up the impugned order, my lord.
Yes.
My lord, if my lord takes up my lord, we have raised objection against the medical certificate that was issued. Against that, we have filed our opposition before the tribunal, and they have filed their reply. My lord, but my lord, the genuinity of the medical certificate was under challenge. My lord, the tribunal decided that it is genuine. My lord, that is what.
Why should you interfere under 226? It is not a gross.
My lord,
error.
because
It's
this
an appreciation of the evidence court has
No, my lord,
that
because this medical certificate is also a vital part in deciding the OA application.
Oh, acha. Why? The illness was relevant in the
My lord,
context.
because the appeal was also dismissed for default.
So medical certificate is annexed here.
Yes, my lord, they have. My lord, I have filed the OA application.
No,
and
in your application, you have annexed the annex here. So show us that medical certificate. What was your ground of challenge to the medical certificate? First, let us see that medical certificate.
It is the medical certificate that has been filed by the private respondent. My lord.
Yes, but they filed it. You must annex that.
Yes, my lord. Page 63, my lord.
That is what we are asking. Obviously, they filed. Otherwise, how?
Yes.
Their delay was continued. You will file it. So, what is the ground of challenge to this?
My lord, if my lord takes up the date, my lord, that is 6/4/2015, my lord.
Yes.
My lord, and states that the middle portion that the said person was ill from 21/1/2015 to 7/4/2015.
Yes.
But they are stating that it is it is not 6/4, it is 6/11.
Is
But that and tribunal also decided that it is 6/11.
You can't read this. Certified such and such. Medipur was suffering long from such and such joint pain. Oh, on 6th of April, how could you give a certificate till 7th of?
Yes. That is the.
Yes, this is clear. It's clear. 6/4 should have been adverted to.
That is 6/11 to the
Cannot, definitely not. It's clear. There's a line in between the two lines.
So for my
Almost with 90% impairment of vision can also find this to be 4.
So my lord, that is my lord, it seems to be the 4, 6/4. That is not
Virtual reality or artificial intelligence.
That is 11.
4 is 4. It's definitely not 4. At a cursory perusal, it's clear 4. We'll remand it to the tribunal. This is perversity. This is not reappreciation. This is perversity.
This is my lord, kindly see the medical certificate. I have.
We are seeing only the medical certificate.
I have yours.
Let us see. The original you have. It was not produced in the tribunal.
Yes.
How could you have it then?
Xerox copy.
The original was not also produced.
No, man.
Din. Xerox copy also. Yes, yes. কোন অ্যাঙ্গেল থেকে আপনার 11 মনে হচ্ছে? From which angle? From the reverse also it's 4.
It's 611 so far my instructions is 611.
Oh, your instruction. Our eyes are better informed than your instructions. Sorry. এটা ফেরত দিন। A short point is involved in the present challenge. First up, the learned tribunal condoned delay in preferring an original application by the private respondent on the strength of a medical certificate produced by the private respondent, the applicant before the tribunal. First up, learned counsel for the petitioner points out that whereas it is evident from the certificate that it was issued on April 6, 2015, the tribunal, in a perverse manner, came to the conclusion that it was dated November 6, 2015, accepting the private respondent's contention to that extent. First up, next para, we find from a bare learned counsel for the respondent seeks to rely on the original of the said document and submits that the date was rightly interpreted by the tribunal as November 6 and not April 6, 2015. First up, next para, on a plain even on a cursory perusal of the medical certificate, a copy of which is annexed to the present writ petition at page 63 thereof, and an original of which was temporarily handed over to us by learned counsel for the private respondent himself, it is as clear as daylight that the date of issuance of the said purported medical certificate was within double inverted 6 full stop 4 full stop 2015 double inverted close full stop. Next para, thus, there was no scope of misconstruing the date as double inverted 6.11.2015 double inverted close full stop. Next para, however, in the said medical certificate, surprisingly, the concerned doctor gave certified that the private respondent was suffering from certain ailments from January 21, 2015 to April 7, 2015. Push up next para, it is quite surprising as to how on April 6, 2015, at the time of issuance of the certificate, the concerned doctor was prophetic and predicted that he would be that the private respondent would be ill till the next date. Push up next para, moreover, it is absurd that on April 6, 2015, a certificate is given, stating in the past tense that the private respondent was suffering from such ailments up to a future date, that is April 7, 2015. Full stop next para. We find from the impugned order that the learned tribunal did not advert in detail to such gross discrepancy in the medical certificate, which raises a serious doubt as to the veracity of the same. Full stop next para. Accordingly, such error amounts to perversity, and the impugned order cannot be sustained on such count. Full stop. Thus, WPLRT 133 of 2026 is allowed on contest, thereby setting aside the impugned order dated November 17, 2025 and passed by the 4th bench West Bengal Land Reforms and Tenancy Tribunal in MA 998/2016, in connection with OA 1764/2015 bracket LRTT bracket closed, and remanding the matter to the tribunal to rehear the condonation application upon adverting scrupulously to the discrepancies as pointed out above, in the medical certificate produced by the private respondent before the tribunal, and come to a reasoned conclusion on the condonation application on the basis of such perusal. Full stop. No orders for cause urgent certificate.
My lord, I bow down to your lordship.
Thank you so much.
She was appearing with me.
I pick to appear on behalf of the private respondents, your lordship.
But I'm for the petition state respondent in this matter. Now, my lord,
Yes.
24 and 25 was the identical. I'm requesting my lord to take 25 first, my lord, because
দুটো বোর্ডে দেখিয়ে দিন। You are appearing in both 24 and 25.
24 and 25, I am praying for admission. I do not know whether they will use affidavit or not.
No, I'm for the
What admission? We may dismiss at the outset. Move it.
My
No
lord,
question of admission before in this court.
my lord.
135 should be taken up first. Why, Mr. Bhattacharya?
my lord, unfortunately, my lord, one that matter, my lord,
You got
24
prepared in that.
No, no, my lord. The state first brief 25, then my lord 24. So I have prepared 25.
Very well.
Both are similar, my lord. Identical
No,
fact,
no, not
everything
difficult.
same.
Please move 135 first. You are also prepared on that.
I'm not in 135.
You are not in.
Then my lord 20, my lord, let it, my lord, the first
Same
matter.
advocate on record. Same advocate on record.
24 and 25.
24 and 25, advocate is Porichito or Porichita?
My lord, my lord.
Porichita Rai.
Two matters.
Porichita.
Two matters.
Both matters, Porichita Rai is advocate on record.
Only on that, on those two matters only.
These two matters, not
These
those.
two matters, huh? These two matters.
Porichito Rai is not you.
My junior.
So you say you are
Advocate on
appealing
record.
only in 24 and not 25?
I am in 25.
Move 25.
But I have marked 24 better.
All right, my lord, let him move in 24, my lord. I don't
All
have
the
any
same,
problem.
my lord.
Let him move, my lord, 24.
Move
My lord, I don't
24.
have any problem.
Yes. We are feeling like a panchayat sort of resolving these, which matters should be taken up.
My
first.
kindly consider, my lord.
It's a
My
we are a
kindly consider.
pseudo panchayat now. Yes.
My kindly consider. My,
Yes. Please move that. What is the matter?
my lord, I have purchased the land from Binoda Dasi. That is at page 57, my lord. In 1962. My lord, may I to cut short the matter, I may describe that the said Binoda is the one A who sold to B.
You are B.
I'm not B.
Achha.
I'm C. But
Because
I'm
B-
C.
So how is B and C related?
And I am describing
We don't mention B, C together. So how are B and C related?
B sold to C.
Okay. So your vendor was B.
My vendor was B, and I am saying that I stepped into the shoes of the Binoda
When
in
did you-
1962. As because there are the time gaps.
Binoda sold to B.
B and
Which year?
in 1962. That is the
You
main
purchased from B when?
in 2013.
Very well.
My lord, I want to canvass my case in
Yes.
such a fashion, my lord, before your lordship, my lord, kindly protect me. My lord, I purchased from 1962. As because I stepped into the shoes of
All right.
my lord.
So then what?
My lord. And I am describing the subsequent purchaser of the same plot of land by the same alleged vendor. I do not know whether she was alive or not, Binoda.
When did she sell to him?
It is 1973.
So before you.
Before me.
Binoda sold to your common
my
vendor
lord, I'm grateful.
in 1962.
My lord.
1973, B sold to them. And 2013, B sold to
B
you.
sold to them now. A sold to them.
Binoda herself sold to them.
A to D.
Achha. So after Binoda.
That is the contest of the case.
Oh, so if after Binoda sells the property to your vendor,
my lord,
she did not have any title, could not transfer to
my
them.
lord, I am grateful, my lord.
So let us allow.
Huh? My lord,
then what happened?
My lord, my case is.
You understood your case.
My lord, I am grateful, my lord. My lord, my case is. My lord, my case is in 1962. In 1962, my lord, Binoda was the owner of 2.11 decimal of land.
Right.
My lord, she sold 1.61 to B. 1.61 to B.
Yes.
And B sold to me in 2 deeds, my lord.
That's entire thing. 1.61 by 2 deeds.
By 2 deeds, my lord. That's why 2 mutation was allowed, my lord, by the BLRO under section 50 of the WBLR Act, and thereby 2 orders were passed in my favor, my lord. And my name was recorded in 2013 in the BLR office.
Both the deeds were of 2013.
Same date. Same date.
So mutated. Then?
So mutated and allowed.
Yes.
2013 to 16, 2016, my lord.
Living peacefully up to 16.
Peacefully, my lord.
Then they disturbed your peace.
He appeared, my lord, by a section 5 application before the appellate authority. First time. My lord, I am repeating, my lord, kindly forgive me, my lord, from 70 through to 2016, absent.
62 to 2016.
73 did.
73 to 20.
2016, my lord. This is my case, my lord. He was absent, no possession, no title. All on a sudden, he filed an application, my lord, under section 5 of the Limitation Act, allowing it an application for cancellation of my mutation.
So you challenge the BLR order before
challenging the BLR order by 2 separate mutation case and 2 separate appeal, and thereby 2 separate cases before your lordship.
Right. Then what
My
happened?
lord, he purchased, he filed the application under section 5 without any ground, without stating any plea, that when he got the possession of the fruit land, there is nothing mentioned in the said deed that a possession delivered or not. My lord, he was not in possession, not in use of the property, and I may be permitted to say that I am in possession and in cultivation from 1962 to 2016 and 2026 till date. This is my case, my lord.
So what that was allowed by the
That was allowed by the
BLR.
appellate authority, and thereby the said court below said that the said deed of 1962 is erroneous and that is not proper. So the mutation order passed in my favor is set aside.
DLLR said that 1962 is not proper.
My lord, my lord.
Why not proper according to the DLLR?
My lord, they have taken a plea in the section 5 and another application. In therein they said that my vendor Binoda or his vendor Binoda was a scheduled tribe, and I have not taken any permission from the BLRO, from the BLRO, a revenue officer, and they are saying, that they have got a something permission from the revenue officer in 73.
So your transfer was a nullity. According to them.
My lord, I'm grateful, my
What
lord.
is your answer to that?
My lord, my case is, if there is 2 deeds, one is fraud, then their case goes, my lord. Fraud on the 3 grounds, my lord. Fraud on 3 separate grounds. My lord, kindly come to their deed, my lord. I am very much cracking up on the section 5 application, because they have no ground, now no fact said in the said application.
Section 5 was allowed. Their appeal was also allowed.
Appeal was
on
also
merits.
allowed.
You challenged that before the tribunal.
My mutation was allowed. They filed.
You have challenged that DLLR order allowing the
challenge. They challenged.
No, my
DLR order was challenged.
DLLR, appellate authority.
DLLR.
Appellate authority passed against you.
Sorry, my lord.
So appellate authority passed the order against you.
My lord.
Directing mutation in their name.
My lord.
You challenged that before the tribunal.
I challenged before the tribunal.
And tribunal has
rejected. My prayer.
So therefore the tribunal has not only proceeded on the section 5 but also the main merits. Did you challenge
before the DLRO section 5? I am cracking.
DLRO section 5 Did you challenge that separately at that point of time?
I have challenged. I have filed objection that they have not.
The section 5 was allowed first, then the appeal was taken up. Then the appeal was decided by the appellate authority on merits.
That section 5 ought to have been rejected because there is a question of conflict of title, conflict of possession, and conflict of
the section 5 was allowed first. Then the appeal was taken up. Then the appeal was disposed of on merits.
My lord.
Finally, after appeal being disposed of on merits, you have challenged that appeal, that judgment. Did you, at any point of time before that, challenge the order whereby the section 5 was allowed?
I have challenged before the DLRO. By section 5 by on
section 5 was allowed by the DLRO.
My objections were turned down.
Turned down and section 5 allowed and the appeal was taken up.
Taken up.
So did you challenge the order of the appellate authority allowing the section 5? Did you challenge that before the tribunal?
Not separately.
How can you reopen that after you participated in the appeal and had it disposed of on merits? Now you are going back and challenging the section 5. How can?
My lord, it was in a composite order. It was allowed.
In a single order, it was allowed.
In the same order.
Let us see the DLR order. Appellate authority order first. Yes.
It will be 108. There is a index, my lord. Judgment order dated 8/7/16 passed by the learned additional district magistrate. Transfer, page number 108. Index, my lord.
Yes.
My lord. 108. Section 5 for condemnation delay is received on this court on so and so.
Yes, yes.
Requisite that will annexed with this appeal. And thereafter the composite order was passed at page 124. Page 124. My lord, may excuse me, I am jumping something, my lord.
No, no, no. We cannot prevent you from jumping.
My lord, to cut short and to make it straight.
Please do that. It will help us.
Page 124, top line.
So we want to see first the section 5 must have been allowed first. Where is that portion of the order? Please show us that.
Big order.
Inner page 3, my lord. Inner page 3 of.
Yes, page 113-14.
Page 8th of July.
114, page 114 in our copy. That has been allowed.
958 days delay.
Bottom para.
What was the delay?
900 and
submitted that I am in possession from 1962 and they claim that they purchased in 1973.
No, mutation took place only in 2013. They have challenged the mutation.
They have challenged mutation after 3 years.
That is what we are saying, 3 years.
And they have not applied for any mutation, my lord. Kindly, respectfully, I will submit, my lord. They have.
That will be on the merits of the appeal.
My lord.
That will be on the merits of the appeal.
My lord, 73.
For section 5,
my
let
lord,
us
73 to 2016, they were absent in the field.
The mutation order, don't jump so much.
My lord,
2 steps at a time.
My lord.
2013 mutation order was passed. 2013 it was passed. They challenged that mutation order in 2016. 3 years in between. First, they had to explain the delay in of 3 years, or if there was any delay.
Submitting 3 years, I am saying 73 to 16. Because they were never gone into the field, there is no inspection report. My deed is subsisting. My deed is
That
substituted.
is on the merits of the appeal, sir.
My lord.
That
my
is on the
lord.
merits of the
Sorry,
appeal.
my lord.
Whether for their non-mutating their names,
My lord.
whether they acted upon that deed
My
for
lord,
so
never
long,
acted upon.
that will be on the merits of the appeal.
My lord.
We cannot look into the appeal. That appellate authority could not look into the appeal
My lord.
before the condonation application for preferring the appeal was allowed.
Simply allowed.
So that therefore we
Not
are
from
now
anyone.
focusing. You are saying that section 5 should not have been allowed.
My lord.
You are saying that the limitation should be counted from 1973.
My lord.
We absolutely don't agree with you, because the order challenged in the appeal was passed in 2013.
So where is
So they
their
only
mutation application? They are holding that the alleged deed of.
that is your only ground. Then we are deciding right now.
My lord, sorry, my lord.
No, that is your ground. That the limitation should be calculated from 1973. Mutation order passed in 2013. They challenged in 2016. And we should calculate limitation from 1973 because they are
I'm submitting that they have no action, cause of action to file the appeal.
Newton's third law will apply here.
My lord. Then another.
Newton's third law will apply.
My lord, kindly page number 124, my lord.
124.
My lord, may I proceed, my lord?
No, so section 5 you are no longer challenging.
I'm challenging still.
Still challenging.
My
And still you are saying that it should be limitation should be counted from 1973. So Mahato, you don't understand what you are submitting and you are disturbing. Are you being able to understand what he is submitting?
My lord, that is why I am saying.
You are understanding. We are not understanding. 1973 order is mutation is done in 2013. Appeal is preferred in whenever you are talking, you are speaking, so you can't hear what you are saying and you are giving wrong answers. Our question is very simple. If a mutation is done in 2013,
my favor. In my favor.
We are very happy for you. 2013 it is done, mutation order is passed. They prefer an appeal against the mutation order.
My lord.
In 2016.
My lord.
So therefore, the limitation should be calculated from 2013, which is the cause of action of the appeal. If the condonation is allowed, then while taking up the appeal, this 1973 question can be taken up. So what is your ground? What is the limitation period?
That is the.
What was the ground given in the section 5?
Of the
Section 5.
Authority, section
Yes.
5.
So first you are challenging the
placing that is from 73, they never.
No, that you have understood.
My lord.
What was the delay in preferring this 3 years delay? How did they explain?
Nothing explained, my lord.
Nothing explained. Where is the section 5 application?
My lord, kindly.
Where was the section 5 application?
My lord, page 94, my lord.
Yes.
Page 94. Page 94, para 2. Only para 2 and nothing there.
They said no notice was served. The expression was given.
They have nothing said about 73 to 16 or anything.
They were intelligent, that's why they did not say anything.
And they have not applied for mutation even if they purchased.
That is also
they
not a.
never gone to the field.
So section 5 rightly allowed. Let us go into the appeal now. 90-year-old person was not given notice of the hearing, learnt later.
When, sir?
Found out from the computer link.
When they learned, they have.
Dates are given. Please read para 2. Dates are given.
They have given
On 19th of December 2013, tried to collect. Computer link failed. Then such and such, such and such.
They are
Notice was served on 20.
They have not never applied for mutation. I was in the record of rights. I was in the khajna. I was in the field. I have paid everything from 1962. And the said Binoda.
Even if they don't apply for mutation, does that take away the title? Mutation confers title.
Well,
was it a gift deed? Was it a gift deed?
Their deed.
Sale deed or gift deed? If it
nothing written, my lord.
Nothing written.
Nothing
The deed
written.
copy
My
is
lord,
not
kindly
given.
come to my lord. Kindly come to page 133, my lord.
133.
And may I be permitted to play?
Yes. This is their deed.
This is their deed, my lord. My lord, left hand, my lord.
Left hand, yes.
Left hand, there is a seal, round seal, my lord.
Round seal, yes.
My lord. In the said seal, my lord, kindly see. In the said round seal, 24 Parganas North. My lord knows better than me. In the 1970,
We don't. Yes.
my lord, in 1973, there was no North 24 Pargana, not 24 Pargana. In 1970.
Yes, right. Right.
And another other points, my lord, the officer on the top of the deed, my lord.
Yes.
After the stamp paper, my lord, there is a seal and signature 29/1/73.
You should have filed a suit challenging this on
My lord,
ground of
why
fraud.
should I am in possession? I am with the deed.
DLLR, no, when you came to know, DLLR can decide this
I never
question
know
of
him.
fraud.
My lord, I am grateful, my lord. I never know him. Only I seen him in the.
When you came to know of this document,
my lord,
shouldn't you have filed a suit on the ground of fraud, challenging
my
the
lord,
deed on the
most
ground of fraud?
respectfully, I am taking permission. They should file a suit against me. That my
Or declaration that their deed is fraudulent.
their deed is good. They have never applied
They
for.
need not. They have a registered deed, that is sufficient. If you challenge that,
My lord, the same plot of land allegedly sold by the same vendor and twice, my lord. And the second subsequent deed holder never came to the possession.
Your vendor's deed was bad. Schedule type vitiated by schedule.
Taking point. I say my.
No, but they also purchased from your vendor only.
Not my vendor, my vendor's vendor.
Oh, no, they purchased directly with permission then. Then your vendor's purchase was bad.
My lord, I say that this deed or the permission.
Keeping it parted because we have this bench till 3. Grateful.
I'm grateful, my lord.
Developed.
Your Lordship, may I be permitted to mention one
Bench matter.
single bench matter?
Yes.
Your Lordship, I'm mentioning for correction. There was
By orders correction. Yes, please handle.
there was an order passed by your Lordship on
No,
20
give a mentioning slip, right? To be mentioned for correction.
Lordship, I'm giving it.
Give a mentioning slip.
I'm giving it.
At a mentioning slip, okay. To be mentioned for correction, it will appear as to be mentioned. When I take up the matter, then hand this over with the corrections. I'll do that. And give a notice to the other side if possible. Yes. Why was it fixed on the last session, Mr.
My lords, there was, my lord, today, my lord, I am praying again for some accommodation from my lords. The reason is this, that lordship, the appeal pending before the
appeal against the
appeal is pending before the Honorable Supreme Court, and it could not be heard because on the last occasion
appeal against what? Just
my lord's order of staying the investigation.
That was an interim order. And this is the final order. This is the final hearing.
Final hearing.
So how does it affect the final hearing?
It does not affect Millard, but what is happening, Millard? What I am
use the microphone.
It does not affect Millard. My lord may
suppose
take
if the
up
final order, the interim order is set aside also. Then also we
If
can
it is-
independently
If it
decide.
is set aside, then good for us. But if, my lord, it is confirmed.
It will not be good
final-
if ultimately the writ
If the writ petition allowed, then my SLP will become infraction.
that is no ground.
My lord, that is not a ground, my lord. I am beseeching, my lord. I have never said that is a ground.
Now we'll hear the matter.
Therefore, my lord, come
If
prepared.
it's
We'll,
confirmed, you
yes, my lord.
confirm till disposal of this writ petition.
That's what I'm saying.
If the my lord order is confirmed, when the appeal succeeds, my lord, against an interim order,
Yes.
the order that will be passed, my lord, will be my lord valid till disposal of the writ petition.
Exactly.
In the
exactly,
meantime.
Precisely so. So we can, if we dispose of the writ petition itself, there is no difficulty there.
That's what, my lord, what I'm.
The writ petition further proceedings has been stayed there.
No, my lord.
There's no stay.
It has not been
No
stayed.
stay.
It is just pending, my lord.
We'll finally hear this writ
Then, my
petition.
lord, will kindly fix up a date.
We'll
for
record your submission. We'll give a date.
my lord.
Give us a date. Yes, suits all of you. Give us a date.
তুমি বলো না কোন দিন তোমরা বলো তোমাদের যদি ডেমারার থাকে এই থাকে
You are wearing so many hats. You have to give the date. They'll accommodate themselves.
Yes.
It's a Lahiri and they will accommodate.
I will.
Sorry.
Except my lord, the
D,
first
A,
10 days.
D has become A now. D has become A, yes. Your D has become A now. You have to give the dates. Mr. Banerjee, the Banerjees and the Lahis will
But I
accommodate
have to, my
themselves.
lord, maybe, my lord, D has become A, but they are also overwhelming busily. My both the
Don't put it on me.
I'm-
Whenever you are required.
28 को हुआ है ना
Your lordship, record.
Where we have so many activities, Mr. Trivedi, give us a date, we'll accommodate us.
Lordship, my lord, Friday.
It has to be Friday.
Has to be Friday.
My lord, I'm just trying to calculate, my lord. My lord, 28th, if it suits my lord's diary.
Suits me very well. So
20th
20,
August.
if it suits all of you.
Yes, yes.
28th August.
Very good.
We are very well suited right now.
30th. Learned DSG appearing for the Union of India.
ASG, man.
Aged.
Again. Learned ASG appearing for the Union of India submits that a challenge is pending before the Honorable Supreme Court against an ad interim order passed in connection with the writ petitions. Full stop next para, however, comma, since the said ad interim order was passed only till disposal of the writ petitions, comma, there cannot be any impediment in taking up the writ petitions for final hearing. Full stop next para, in any event, comma, on query of court, comma, it is submitted that no order has been passed by the Honorable Supreme Court staying further proceedings of the writ petitions. Full stop next para, hence, comma, let the writ petitions be fixed for final hearing on August 28, 2026.
This is one request, subject to my learned friends, but records that we are here. Kindly, my lord.
আচ্ছা যেখানটা বললাম যে ডিএসজি সাবমিশন বলে গেলাম এসজি সাবমিশন বলে গেলাম সেখানে একটা লাইন অ্যাড করে দাও learned counsel appearing for the writ petitioners and the bank concur with such submissions.
No. We are not.
Yes, that is pending.
No, it's not for us. We are just present, my lord. That's all that we want. We
are also
the
present. How can you
appearance
just say they are
just the appearance, nothing more than that.
Appearance to be
will be
noted.
there.
Just then no.
Concur with his submission.
No, we don't conquer.
SLP is pending. You are not conquering.
SLP is pending, but we are not concurring with that.
Right.
My lord, no, my lord. We are very clear, my lord.
The line may
This appearance has no meaning. my lord.
the line may be omitted. His appearance
ওখানটা
may be
ওখানটা
noted.
ছেড়ে দিয়ে তারপরে একটা লাইন অ্যাড করে দাও যেখানটা বললাম আপন আমি যেখানে আমার পোরশনটা বললাম আমার ফাইন্ডিংটা সেটা যে আপন হিয়ারিং লার্নেড কাউন্সিল ফর দি পার্টিস দিস কোর্ট ইজ অফ দি ওপিনিয়ন বলে যাব
I'm grateful.
Much.
Hello. Please come prepared on that.
Hello.
My lord, Mr. Sharna had completed his submission, my lord.
Yes, right.
My lord, I am
Bhattacharya.
appearing today also virtually. I am in no position to speak for a long time. But
Mr. Bhattacharya, we'll keep it on some other. We'll keep
my
on
lord, I prepared a written note of
better.
argument, and it will be handed over to.
Have you
my
got a
lord.
copy of this written note?
No, my lord.
I'm giving a copy of it, but they should also give me one. Yes.
Mr. Bhattacharya, we will do this. We are keeping it on some other day. We are recording that a copy of the written notes is given to you, and they will also file the written notes on the next occasion. They will also give an advance copy to you. We'll hear oral arguments on the written notes of arguments. It will be a short hearing on the next day.
My lord. My lord.
How soon can we file your written notes of arguments?
1 week, my lord.
That's sufficient. Very well. You have got a copy of
Yes,
this.
yes,
You have handed
yes.
over. Good. Learned counsel appearing for the. You are appearing for which respondent? Achha. Learned counsel appearing for the respondent numbers 4, 5, and 7 hands over written notes of arguments. First up, a copy thereof is served here and now on the learned advocate for the petitioner. First up, next para, in order to enable the writ petitioner to file his written notes of arguments, comma, the matter is adjourned till August 14, 2026, when it will be listed under the same heading, with the understanding that the parties shall conclude their brief oral arguments on the said date.
My lord,
We have already argued. They'll argue.
we have
My
argued.
lord, my lord, there are four court case references would not be given because the books are with the book binder 1956 to 54 to 1960.
So the references has been given. References have been given here.
References have been given.
That's sufficient for them to prepare themselves. On the next occasion, you can give those copies.
I will give my lord copies of the
Yes, it's on the next. Yes, you were saying.
On 7th, my lord, we will be submitting our written notes. And on the same day, my lord,
No, 14th.
14.
sorry, 14, we will be submitting our written notes. On the same day, we will be making our oral submissions. my lord.
Yes, yes.
With advance copy.
Yes. With advance copy, did you say?
Otherwise, my lord,
Advance copy of the written notes of arguments of the petitioner shall also be served on the learned
otherwise, my
advocate for
lord, they
the
won't be.
respondent numbers 4, 5, and 7.
হয়ে যাবে?
4, 5, and 7 বললাম।
ভিতরে নাকি 21 তারিখে রাখবেন?
4, 5, and 7.
My lord, for abundant caution may be fixed on 21st. My lord, it's one more week.
That's why we are asking you, because 1 week
Because advance
with
copy has to be given. That is the main
advance
issue.
copy takes a few minutes to be given.
On the same day cannot be, at least a day before. That is why, my lord.
Very well. Returnable date, Mr. Bhattacharya, not 14th, 21st.
As my lord, he says.
Grateful, my lord.
August 21. Returnable.
Grateful, my lord.
Grateful, my lord.
Thank you.
I appear for the respondent writ petitioner.
Yes.
My lord, I am making an unusual request on behalf of my lord Mr. Sharnal, who is appearing for the.
He is leading.
Sharnal.
Mr. Sharnal is leading.
It's an unusual.
Sharnal has not come to court.
He is on his legs.
My lord, he has made a request. My lord, my junior's demand is that some kind of order may be recorded.
Your junior's demand will never end. This junior.
Very well, man. Make it not today. We will come back next week.
No, his demand is what? Some kind of order should be passed. What is your demand?
No, my lord, let it be.
No, what was the demand? Now I'm curious.
3:30 সময় ওয়েট করে আছে একটা কি না let it be.
Last matter of the day, তুই কেন খোঁজা?
What was his demand?
I do not have any.
3:30 or
today is 3:30, man.
Today is 3:30.
no, to be fixed at 3:30 on the next date. What is his?
No. No, not 3:30.
No, what is his demand?
Live.
14 তারিখে করবে তো?
রোজই রেডি হচ্ছে 14 করবে।
What was the demand? Let us hear it.
My lord, some kind of order may be recorded.
Yes, we'll record it. We'll record your prayer.
Yes.
On the prayer of the.
Hello, Khushi.
You're the petitioner.
We are the applicant, manner in this. We have filed an application.
On the prayer of the applicant stroke CSC Limited, comma, the matter is adjourned for the day.
For
next Friday.
Okay.
কোথায়?
তোমরা দিয়ে মামলাটা করছো না? ছি।
আমরা তাকিয়েছি মুটবো না।
বসলে না তো তোমাকে আমরা এত ভালোবাসি। পেছন থেকে গালা দিচ্ছি।
জল করে। থ্যাংক ইউ। রবি কাপুর দেশে কেড়ে বাইরে।
Great.